406 District Court is now in session. The Honorable Judge Oscar Hill Jr. presiding.
You may be seated for now. So, obviously we've been, Mr. Perez, Mr. Alanis, we've been working on the charge again this morning. We thought we had it down last night, but as we discussed, there's a few issues that came up this morning. So, do you, each of you have a copy of the most recent version now?
Yes, Your Honor.
Okay.
Yes, Your Honor.
And so subject to the, what we put on the record yesterday, your objection and your request for the original version, the paragraph on 38-2022, is there any objections to this most recent version as the alternative charge?
No, Your Honor, just subject to our objection regarding 3823 yesterday.
Only to those two paragraphs that you had requested, correct?
Charge.
Specially requested charge.
Correct.
Okay. Yes.
Yes. So, and this one's now labeled charge of the court instead of jury instructions, but same meaning. Any objections to the, again, to this as the alternative charge from the state? Any objections from the state?
No objections, Your Honor, by the state.
Okay.
Defense, no, Your Honor.
No objections from the defense side, okay. We're just waiting for the copies, see where they're at with the copies, so we're gonna have copies available for the jury so that they can read along, and they're printing them out. We'll get your copy. Ms. Cross.
Thank you.
Whoever's arguing has to wear this thing.
They're bringing the copies for you. Give the 14 to Mr. Medina. Give me the one for Ms. Kerr. Here's your copy, ma'am. Should have a water here. I'm gonna need a water here, please. I'm gonna need a water, please. Ready for the jury now.
Yes.
Bring the jury in.
It's ready, Your Honor.
All rise for the jury.
You may be seated. Good afternoon now. I was hoping to say good morning. Ladies and gentlemen of the jury, as I mentioned yesterday, all of the evidence has been presented to you. I'm about to read the charge of the court, also called the jury instructions, to you, which is the law that will be applied to the facts of this case. After I read the charge of the court to you, the attorneys will have an opportunity to make closing arguments. Please listen carefully. Members of the jury, the defendant Juan David Ortiz stands charged by indictment with the offense of capital murder, alleged to have been committed in Webb County, Texas, on or about the 3rd day of September 2018 through on or about the 15th day of September 2018. The defendant has pleaded not guilty. Our law... Well, let me pause there. I'm sorry. You haven't passed out the copies?
Oh,
Yeah, okay. There are copies for you to read along. And you may take those with you into the jury deliberation room. But as you notice, they have a stamp called that says copy on it. The one that I have has a stamp that says original. This is the one that has the forms, and this is the one that should be returned back to the court. Okay. Okay, everyone received a copy? Thank you. All right. So where I left off, on paragraph 1. They can pass it along, Mr. Medina. You don't have to walk in front of the room. Let me know when everyone has received a copy. Does everyone have a copy now? Thank you. Okay. Paragraph 1. Our law provides that a person commits the offense of murder if he intentionally or knowingly causes the death of an individual. Our law provides that a person commits the offense of capital murder when such person intentionally or knowingly causes the death of more than one individual during different criminal transactions, but pursuant to the same scheme or course of conduct. Individual means a human being who is alive. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance or any device readily convertible to that use. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Our law provides that the time of the offense alleged in the indictment must be some date anterior to the presentment of the indictment and not so remote that the prosecution of the offense is barred by limitation. The phrase on or about means that the state is not required to prove the alleged offense happened on that exact date. There is no limitation period for the offenses of murder and capital murder. Therefore, it is sufficient if the state proves that the offense alleged was committed sometime before December 5th, 2018, which is the date the indictment was filed. Now, if you unanimously find from the evidence beyond a reasonable doubt that the defendant, Juan David Ortiz, committed at least 2 of the following charged offenses of murder: on or about the 3rd day of September 2018 in Webb County, Texas, the defendant Juan David Ortiz did then and there intentionally or knowingly cause the death of an individual, namely Melissa Ramirez, by shooting Melissa Ramirez in the head with a firearm. On or about the 13th day of September 2018 in Webb County, Texas, the defendant Juan David Ortiz did then and there intentionally or knowingly cause the death of another individual, namely Claudine Luera, by shooting Claudine Luera in the head with a firearm. On or about the 15th day of September 2018 in Webb County, Texas, the defendant Juan David Ortiz did then and there intentionally or knowingly cause the death of another individual, namely Giselda Alicia Cantu, a.k.a. Giselda Hernandez, a.k.a. Griselda Alicia Hernandez, by striking Giselda Alicia Cantu, a.k.a. Giselda Hernandez, a.k.a. Griselda Alicia Hernandez, in the head with an unknown object or by shooting Giselda Alicia Cantu, a.k.a. Giselda Hernandez, a.k.a. Griselda Alicia Hernandez, in the neck with a firearm on or about the 15th day of September 2018 in Webb County, Texas. The defendant, Juan David Ortiz, did then and there intentionally or knowingly cause the death of another individual, namely Humberto Ortiz, a.k.a. Janelle Ortiz, by shooting Humberto Ortiz, a.k.a. Janelle Ortiz, in the head with a firearm. And you unanimously find beyond a reasonable doubt that two or more of the murders alleged above were committed during different criminal transactions, but pursuant to the same scheme or course of conduct. Then you will find the defendant guilty of the offense of capital murder as charged in the indictment, and do not consider paragraph 6 through 9. You are instructed that if you have found beyond a reasonable doubt that at least two of the above alleged individuals were murdered pursuant to the same scheme or course of conduct as instructed above, you must be unanimous. All 12 of you must agree on which two individuals were so murdered. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, or if you are unable to agree, you will determine whether the defendant is guilty of one of the lesser included offenses, and next consider paragraph 6. We're on page 5. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 3rd day of September 2018 in Webb County, Texas, the defendant, Juan David Ortiz, did then and there intentionally or knowingly cause the death of an individual, namely Melissa Ramirez, by shooting Melissa Ramirez in the head with a firearm, then you will find the defendant guilty of the lesser included offense of murder of Melissa Ramirez, and do not consider paragraphs 7 through 9. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, or if you are unable to agree, you will determine whether the defendant is guilty of a different lesser included offense, and next consider paragraph 7. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 13th day of September 2018 in Webb County, Texas, the defendant, Juan David Ortiz, did then and there intentionally or knowingly cause the death of an individual, namely Claudine Luera, by shooting Claudine Luera in the head with a firearm, then you will find the defendant guilty of the lesser included offense of the murder of Claudine Luera, and do not consider paragraphs 8 and 9. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, or if you are unable to agree, you will determine whether the defendant is guilty of a different lesser included offense, and next consider paragraph 8. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 15th day of September 2018 in Webb County, Texas, the defendant, Juan David Ortiz, did then and there intentionally or knowingly cause the death of an individual, namely Giselda Alicia Cantu, a.k.a. Giselda Hernandez, a.k.a. Griselda Alicia Hernandez, by striking Giselda Alicia Cantu, a.k.a. Giselda Hernandez, a.k.a. Griselda Alicia Hernandez, in the head with an unknown object, or by shooting Giselda Alicia Cantu, a.k.a. Giselda Hernandez, a.k.a. Griselda Alicia Hernandez, in the neck with a firearm, then you will find the defendant guilty of the lesser included offense of the murder of Giselda Alicia Cantu, a.k.a. Giselda Hernandez, a.k.a. Griselda Alicia Hernandez, and do not consider paragraph 9. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, or if you are unable to agree, you will determine whether the defendant is guilty of a different lesser included offense, and next consider paragraph 9. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 15th day of September 2018 in Webb County, Texas, the defendant, Juan David Ortiz, did then and there intentionally or knowingly cause the death of an individual, namely Humberto Ortiz, a.k.a. Janelle Ortiz, by shooting Humberto Ortiz, a.k.a. Janelle Ortiz, in the head with a firearm, then you will find the defendant guilty of the lesser included offense of the murder of Humberto Ortiz, a.k.a. Janelle Ortiz. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty. Paragraph 10. During the course of the trial, you heard testimony from certain witnesses about what other persons had told them, in which the court instructed you not to consider the testimony for the truth of the matter asserted. You may only consider the testimony for the purpose for which it was admitted. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with an offense gives no rise to inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty. It must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. A grand jury indictment is the means whereby a defendant is brought to trial in felony prosecution. It is not evidence of guilt, nor can it be considered by you in passing upon the issue of guilt of the defendant. The burden of proof in all criminal cases rests upon the state throughout the trial and never shifts to the defendant. You are further instructed that it is only from the witness stand that the jury is permitted to receive evidence regarding the case, or any witness therein, and no juror is permitted to communicate to any other juror anything he or she may have heard regarding the case or any witness therein from any source other than the witness stand. Written statements made by a witness or police reports made by officers are tendered by the attorneys to opposing counsel for purposes of cross-examination and are not part of the evidence unless introduced in evidence. Many times statements and reports may be marked with an exhibit number but are neither offered nor received in evidence. From time to time throughout the trial, the court has been called upon to pass on the question of whether or not certain offered evidence might properly be admitted. You are not to be concerned with the reasons for such rulings and are not to draw any inferences from them. Whether offered evidence is admissible is purely a question of law. In admitting evidence to which an objection is made, the court does not determine what weight should be given such evidence, nor does it pass on the credibility of the witness. As to any offer of evidence that has been rejected by the court, you, of course, must not consider the same. As to any question to which an objection was sustained, you must not conjecture as to what the answer might have been or as to the reason for the objection. You are instructed that the statements of counsel made during the course of trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. While you should consider only the evidence, you are permitted to draw such reasonable inferences from the testimony and exhibits as you feel are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the facts which have been established by the evidence. Our law provides that a defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded a defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer to nor allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You have heard evidence that the defendant made a statement to Federico Calderon and E.J. Salinas on September 15, 2018. If you find the defendant did make a statement, you may consider that statement against the defendant only if you resolve a preliminary question in favor of the state. A statement of an accused may be considered against the accused only if the statement was freely and voluntarily made without compulsion or persuasion. Therefore, you may consider any statement you believe the defendant made only if you all agree the state has proved beyond a reasonable doubt that the defendant made the statement freely and voluntarily without compulsion or persuasion. Unless you find the state has proved beyond a reasonable doubt that the statement to Federico Calderon and E.J. Salinas on September 15, 2018 was in fact made and that it was made freely and voluntarily, you must not consider the statement for any purpose. You are instructed that unless you believe from the evidence beyond a reasonable doubt that the alleged confession or statement introduced in evidence was freely and voluntarily made by the defendant without compulsion or persuasion, or if you have a reasonable doubt thereof, you shall not consider such statement or confession for any purpose, nor any evidence obtained as a result thereof. You are further instructed that under our law, a confession of a defendant made while the defendant was in jail or other place of confinement or in custody of an officer shall be admissible in evidence if it appears that the same was freely and voluntarily made without compulsion or persuasion, provided, however, that it be in writing by the accused and show that the accused has been warned prior to making such statement or confession by the person to whom the same is made, that one, he has the right to remain silent and not to make any statement at all, and that any statement he makes may be used as evidence against him at his trial. 2, any statement he makes may be used as evidence against him in court. 3, he has a right to have a lawyer present to advise him prior to and during any questioning. 4, he may have his own lawyer, or if he is unable to employ a lawyer, he has a right to have a lawyer appointed to advise him prior to and during any questioning. And 5, he has a right to terminate the interview or questioning anytime. So in this case, if you find from the evidence, or if you have a reasonable doubt thereof, that prior to the time the defendant gave the alleged statement or confession to Federico Calderon and E.J. Salinas on September 15, 2018, if he did give it, the said Federico Calderon and E.J. Salinas did not warn the defendant in the respects just outlined, or as to any one of such requirements just outlined, then you will wholly disregard the alleged statement or confession and not consider it for any purpose, nor any evidence obtained as a result thereof. If, however, you find beyond a reasonable doubt the aforementioned warning was given to the defendant prior to his having made such statement, if he did make it, still, before you may consider such statement as evidence in this case, you must find from the evidence beyond a reasonable doubt that prior to and during such statement, if any, the defendant knowingly, intelligently, and voluntarily waived the rights herein above set out in the said warning, and unless you so find, or if you have a reasonable doubt thereof, you will not consider the statement or confession for any purpose whatsoever or any evidence obtained as a result of same. You are further instructed that if you find from the evidence, or if you have a reasonable doubt thereof, that Federico Calderon and or E.J. Salinas told defendant before he made the confession or statement, if any, that it could be used for him, and that such a statement by Federico Calderon and or E.J. Salinas was an inducement to defendant to make said confession, then you will wholly disregard said confession, and you will not consider it as evidence or for any purpose, nor consider any evidence obtained as a result thereof. You are further instructed that under our law, a confession of a defendant made while the defendant was in jail or other place in confinement or in the custody of an officer shall be admissible in evidence if it appears that the same was freely and voluntarily made without compulsion or persuasion. So in this case, if you find from the evidence, or if you have a reasonable doubt thereof, that prior to the giving of the alleged confession of the defendant, if any officer threatened or in any manner coerced the defendant or used improper influence, or if any officer questioned him persistently over a long period of time without allowing him to contact an attorney or any other relative, and the defendant, through fear or under duress or under any other improper influence, was thereby induced to make said statement, then such statement would not be freely made and voluntary. And in such case, if you find the fact so to be, or if you have a reasonable doubt thereof, you will wholly disregard the alleged confession or statement and not consider it for any purpose, nor any evidence obtained as a result thereof. No evidence obtained by an officer or other person in violation of any provisions of the Constitution or laws of the State of Texas or of the Constitution or laws of the United States of America shall be used against the accused on the trial of any criminal case. The state must prove beyond a reasonable doubt that the evidence was not obtained in violation of the law. Now, therefore, if you find beyond a reasonable doubt that, 1, the defendant abandoned his white truck, or 2, that the officer searched the truck at the Stripes and or the Webb County Sheriff's Office substation pursuant to a valid inventory search, or 3, the searching officer had probable cause to search the truck at the Stripes and or the Webb County Sheriff's Office, then and only then may you consider all the evidence obtained as a result of that search of the truck. If you do not find that fact beyond a reasonable doubt, then you will disregard all evidence obtained as a result of the search of the truck. Occasionally during jury deliberations, a dispute arises as to the testimony presented. If this should occur in this case, you shall inform the court and request that the court read the portion of the disputed testimony to you from the official transcript. You shall not rely on your notes to resolve the dispute because those notes, if any, are not official transcripts. The dispute must be settled by the official transcript, for it is the official transcript rather than any juror's notes upon which you must base your determination of the facts and ultimately your verdict in this case. The exhibits that have been admitted into evidence are in the custody of our official court reporter. Should you request to receive the admitted evidence in the jury deliberation room, you must make your request to the court in writing. A fact may be established by direct evidence or by circumstantial evidence or both. A fact is established by direct evidence when proved by documentary evidence or by witnesses who saw the act done or heard the words spoken. A fact is established by circumstantial evidence when it may be fairly and reasonably inferred from other facts proved. At this stage of the proceedings, you are concerned only with whether the defendant is guilty or not guilty and will not concern yourselves with the punishment, if any, which might or might not be assessed. Your sole duty as jurors in this case is to determine whether the defendant is guilty under the indictment in this cause and restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony. But you are bound to receive the law from the court, which is hereby given to you, and be governed thereby. You must not consider any legal principles not contained in these instructions. You have no right to disregard or give special attention to any one instruction, or to question the wisdom or correctness of any rule I may state to you. You must not substitute or follow your own notion or opinion as to what the law is or ought to be. It is your duty to apply the law as I explain it to you, regardless of the consequences. It is also your duty to base your verdict solely upon the evidence that has been presented to you in court. You are instructed that you are not to allow yourselves to be influenced in any degree whatsoever by what you may think or surmise the opinion of the court to be. The court has no right by any word or any act to indicate any opinion respecting any matter of fact involved in this case, nor whether the defendant is guilty or not guilty. The court has not intended to express any such opinion, and if you have observed anything which you have or may interpret as the court's opinion upon any matter of fact in this case, or whether the defendant is guilty or not guilty, you must wholly disregard it. After you have retired to the jury room, you should select one of your members as your presiding juror. The first thing the presiding juror will do is to have this charge read aloud. It is his or her duty to preside at your deliberations, to vote with you, and, when you have unanimously agreed upon your verdict, to certify to your verdict. The presiding juror will certify thereto by using the form attached hereto by writing guilty or not guilty where indicated on the form as it conforms to your verdict, and signing his or her name as presiding juror. Each juror must decide the case for themselves, but only after an impartial consideration of the evidence with their fellow jurors. In order to return a verdict, each juror must agree thereto, but jurors have a duty to consult with one another and to deliberate with a view to reaching an agreement, if it can be done without violence to individual judgment. In the course of deliberations, a juror should not hesitate to re-examine his or her own views and change his or her opinion if convinced it is erroneous. However, no juror should surrender his or her honest conviction as to the weight or effect of the evidence solely because of the opinion of his or her fellow jurors, or for the mere purpose of returning a verdict. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case which is not shown by the evidence. Do not let bias, prejudice, sympathy, or resentment, or any such emotion play any part in your deliberations. Any verdict you render must be unanimous. That means all 12 of you must agree. These instructions are given to you because your conduct is subject to review, the same as that of the witnesses, parties, attorneys, and the judge. If it should be found that you have disregarded any of these instructions, it will be jury misconduct, and it may require another trial by another jury. Then all of our time will have been wasted. The presiding juror or any other who observed the violation of the court's instructions shall immediately warn the one who is violating the same and caution the juror not to do so again. Paragraph 27. Suitable forms for your verdict are attached to the charge for your convenience, if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. After you have retired to the jury deliberation room, no one has the authority to communicate with you except the court bailiff. Do not attempt to talk to the bailiff or the attorneys or the court or anyone else concerning any questions you may have. Instead, address your inquiry to the court. Any communication relative to the case must be written, signed by the presiding juror, and shall be submitted to the court through the bailiff. Given at 12:33 p.m. on the 7th day of December 2022. And as I mentioned, there are verdict forms attached that you may refer to and utilize as you deem necessary. Is State ready for their closing arguments?
State's ready, Your Honor. Ms. Karina Rios will be presenting the first part of the state's closing.
I may proceed, Your Honor.
Warning at 5 minutes?
Yes, sir. You are ready. Do you remember when we sat at jury selection and Mr. Alanis told you that this case was very important, that it was very big? Truer words have not been spoken. We have brought you all the evidence, and you are ready to render a verdict. You are ready to bring justice to the victims and to their families. Now, the first thing that you are going to do when you go back to deliberate is you're going to select your foreperson. And that foreperson is going to read the instructions again to you. And these instructions are going to serve as your roadmap. So where does this roadmap lead you? It's going to lead you first to definitions, knowingly. I put up the entire definition, but I want you to focus on one word, aware. He is aware that his conduct is reasonably certain to cause the result. Intentionally. Focus on the desire. The desire to engage in the conduct or cause the result. And how do we know what desire is? Desire can be seen the moment somebody picks up a gun, wraps their finger around the trigger, and pulls, pulls, pulls. We've seen that. We've seen that in each of these scenes. 3 times that desire at Melissa's. 2 times that desire at Claudine's. 3 times that desire at Guisela's. And 1 final time that desire with Janelle. What's murder? A person commits the offense of murder if he intentionally and knowingly causes the death of an individual. And what about capital murder? More than one murder pursuant to the same scheme or course of conduct. And I'm going to refer you to page 3, paragraph 5 of your jury instructions. It says that you must unanimously find that he committed at least two of these murders pursuant to the same scheme or course of conduct. And we believe you will. We believe that you will find every single one of these pursuant to the same scheme or course of conduct. And here are all the murders that you have. On September 3rd in Webb County, Juan David Ortiz intentionally or knowingly caused the death of Melissa Ramirez by shooting her. On the 13th of 2018, he caused the death of Claudine Luera by shooting her. On September 15th, he caused the death of Guiselda Hernandez by shooting or striking her. And on September 15th, he intentionally and knowingly caused the death of Janelle Ortiz by shooting her. And all of these were done pursuant to the same scheme or course of conduct. Let's talk about that. Let's talk about the same scheme or course of conduct. Remember that you can ask for evidence. I want you to write this down. State's Exhibit 110. Disc 7, where he tells us the entire story. That's the story. As for State's Exhibit 116, the transcript. You can read what he says. You can read it as you follow along. You saw all of us referring to it while we were taking notes, flipping the pages. You didn't get to do that during the trial, but you're going to get to go back and do that now. And he will tell you in there why he did this. At least 4 times he's going to say it in there. 4 times he's going to say it in there. I was cleaning up the streets. 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 And now we'll also talk about the rights that he is afforded. Because as we stood here, the first day of trial, he stood there without a single piece of evidence, and he was a free and innocent, or he was an innocent man. And as we started this trial, we started pulling together the puzzle pieces. Every single witness that came up here gave you some pieces to put together and put together and put together. And we accept this burden. We accept the burden of having to prove this case beyond a reasonable doubt, ladies and gentlemen. Why? Because we believe we've surpassed it. If the presumption of innocence is at sea level, we are standing atop the Mount Everest of evidence. It is all there. You can look at everything. And as every single witness came up here and handed you a new piece of the puzzle, a new piece of evidence, what do you start to see? You start to see what he saw that day. In his own words, a monster. Now, if you don't believe that one of these, the two or more of these were done pursuant to the same scheme or course of conduct, or you have reasonable doubt, then you'll be able to determine each of these individually. But let's talk about reasonable doubt. You have to ask yourself 3 questions. Do I have doubts? Are they reasonable? And do they go to an element of the case? I'm just going to ask you to use your common sense. I'm just going to ask you to use your perspective to determine this case. Now, you are also charged with determining witness credibility. So what does that mean? You are the ultimate judges of the facts. You can believe some, all, or none. Everything we brought you, consistent, corroborated, credible. Let's talk about Erica. You all saw the trooper's body cam. When she comes up to him and she tells him what happened to her, everything she said in that body camera, consistent with what she told you from that witness stand. Everything she told the investigators, corroborated by Ortiz's own statements. Everything. And credible, you get to decide. But she subjected herself to Mr. Perez's cross-examination. She told you her faults. She told you her story. And more than anything, she came up here to tell you her truth. What happened to her that night. You also get to decide Ortiz's confession and whether it was freely and voluntarily made. And we submit to you that it was. It was obtained without any promise, coercion, or intimidation. I'm going to refer you to what Captain Calderon said on the stand. It was an accommodation, not an inducement. There was no quid pro quo. And let's talk about these accommodations that defense brought up. They brought them up in their opening statements. They told you, they brought up all these things that he was promised. They brought you all these things. But who's the first one to mention breaking down the door? David. Who's the first one to say, I want my wife to keep my pension? David. Who was the first one to say, I want a family picture, please give me my family picture. Here is the passcode to my phone. David. Who asked to be put in isolation because it's better for everybody involved? David. None of these things came from the investigators. He asked for these things. And they said that they would have done these things or offered or tried for anybody sitting across the table from them. This is not exclusive to Ortiz. This was not a one-time thing. And you know what? How else we know that he gave this voluntarily and freely? He knew his rights. He was read his rights. You all saw that in the video. And let's look at his background. Let's talk about his background for just a second. He's an educated man. He has a bachelor's and a master's in criminal justice. He's a Border Patrol supervisor. He worked at the Border Intelligence Center. And you guys saw it in the videos. Maybe not when he was talking to, both when he was talking to Captain Calderon and to Ranger Salinas. He told them, I was involved in all these operations, and let's talk about those. Unit Stone Guard, the different crack houses that he took down, the Targeted Enforcement Unit. He talked about arrests he'd made. He talked about chases he'd done. He talked about it all. He has been Captain Calderon. He has been Ranger Salinas. He has sat across from somebody else to do an interview or interrogation. He knows what he had to do. He could have stopped talking. He could have asked for a lawyer, and he never did. Now let's talk about the truck. They want you to believe that this was an illegal search. They don't believe it. Now let's talk about this. What did everybody tell you happened when they saw him at the Stripes? He turned and ran. He acknowledged that it's his truck, but he turns and ran in the opposite direction. And even then, no search was done at the Stripes. They want to tell you that they manipulated the truck. They opened the door. They took some photos, preservation pictures, to make sure that they knew that it was all there, what it looked like at the time. And they did not do an inventory there. They want to harp on the fact that it says inventory search, but then it says no inventories conducted. What does that matter? It says no inventory search was conducted. And they had probable cause. At that point, they had probable cause. What did Ranger Salinas tell you? I wanted to get it in a secured environment. He could have searched that truck at the Stripes. He could have. He flashed his light into that car, into that truck, that matched the description that Erica gave, that belonged to the individual that Erica identified. And what did they see? What did he see? The pink purse, the tall boys, and a holster. He could have gotten into that truck at that point, and yet he didn't. Why? Because he wanted to preserve the evidence. Look at the evidence retrieval form. It's all there. They did their best to bring you all the evidence. They did their best to keep the integrity of the evidence for you all to decide. And now, defense is going to come up here, whether it's Mr. Perez or Mr. Fuchs, and they're going to come up here, and I suspect that they're going to tell you the same thing, that the statement was coerced, that the search was illegal, that there's just not enough evidence. But I want you, as you listen to them, to stay focused. Use your common sense and rely on your life experiences. And if you remember nothing else from what I told you, I want you to remember this. When they come up here, it's not about what they tell you. It's about what we showed you from that witness stand. Your Honor, I will reserve the rest of my time for Mr. Alanis.
The defense may proceed.
Good afternoon, ladies and gentlemen. The first thing I want to do is thank you for taking the time out of your own private lives and coming down here and listening to this case, because this is how justice is done in each and every case. And I hope that each of you appreciate the fact that anyone accused by the state of Texas is entitled to a trial by jury of his peers. And we have all noticed that y'all have been very attentive during this trial, and we certainly appreciate it. The prosecutor just told you that she knew we were going to come up here and argue that the search was illegal and the evidence shouldn't be admitted. Well, she's quite right, because she is right. The search is illegal, was illegal, and that evidence should not have been admitted for your consideration. In this charge, which the judge has even suggested that the first thing you should do when you go back there after you elect one of your members as the presiding juror is to go back over this. And it's very important you do, because the first part of it is definitions of different various things in the law. And sometimes people suggest that lawyers went to law school simply to learn a foreign language called the law. So if you have a question about, okay, look, I've read this and I still don't understand what it means, you're certainly entitled to send a note out to the judge, and it's in here how you do it, saying, look, we need this clarified. And please do. I mean, don't make a decision without having full knowledge of what your job is. And your job is, you judges. Okay, that's exactly what jurors are. You judge the facts. The judge is the judge of the law, and here it is. This is all the law you will need or can use in the case. You can't use anymore. It's got to be here. But you must follow this law. Sometimes people will say, I'm sure you've all heard the phrase, well, that guy got off on a technicality. Okay, I'm sure everybody's heard that. Well, there are no technicalities. It is either the law or it is not. And as minor as it may seem, as someone may say, I can't let someone go free on that technicality, then what they're saying is, I would ignore my oath as a juror to follow the law that I have sworn to uphold. And it is that serious. If one of us is denied a right, we are all denied our rights. And in this particular case, when the police deny Juan David Ortiz his rights, they're denying us all. That's just how it works and how it's felt. But when the government agents violate rights, we all lose. And in this case, they did. They started by, when they searched the truck, and they're saying it was abandoned. And one thing we kept coming up in this trial was, okay, where are the keys to that truck? At one point, Captain Calderon finally said, well, I got them from somebody. But I'll tell you one thing. You can look in that box, you can look in this one, you can look at all that. You can look under the chairs, wherever. We still don't find them. We still don't see them. And I think that is something critically important to this idea of abandonment, that if I were to leave my keys behind, maybe I don't mean to come back to get it. But if they're in my pocket, that might mean I'm coming back. It's just like when there's a vehicle on the side of the road where DPS has put that orange sticker on the window. That doesn't mean that person's abandoned that car. It means they ran out of gas, they got a flat tire. Now, if it stays there a month, that's pretty obvious. But in this case, and then Ranger Salinas, in my opinion, has the audacity to claim, when he's asked about those keys and the gun, that since he never saw this gun, this Texas Ranger, who has been enforcing the laws of this state for the past 29 years, who is the elite, the Texas Rangers, he's taking a photograph, looking through a lens, and claims he can't see what he's photographing. And then he says, well, since I didn't find the gun, but I found the holster, I sent troopers out looking for that gun to see if he had ditched it when he ran. I didn't hear any witness come in and say, I'm that guy that Ranger Salinas sent out to look for that gun, and I didn't find it. I didn't hear that testimony. And sometimes it'll tell you also in this charge that you can make reasonable deductions from the evidence. And certain times you can make a reasonable deduction from the evidence that that witness was lying. That witness was making things up, as they did throughout. This argument about he was promised nothing, there was no inducement. The first notice they had that Mr. Ortiz wanted to enforce his right to remain silent, and perhaps to a lawyer, and perhaps to terminate it, was when he refused to sign the form. That's the first indicator this guy doesn't want to cooperate. Because if you're cooperating, they got the little check box in the evidence. I don't know what number, but you can check the boxes. Yep, here, I put my initials. But he said, I'm not signing it. I'm not signing anything. In other words, I'm not cooperating. I'm not talking. Then, when he was asked about, well, do you want to talk to us? No. I mean, that should be an indication but to Captain Calderon and Ranger Salinas, no does not mean no. So they continue on. And then the idea, it wasn't a promise, it wasn't persuasion, it was accommodation. Well, if it's not persuasion, if it's not an inducement, when you say the district attorney himself's out in the hallway, he's in the other room, you want us to go put in the good what for you? We'll do that if you talk. Well, if that's not trying to get him to say things he otherwise wouldn't, saying, we can go work this case out right now. And that's before any statements were made to them. He also tried to enforce his, the idea that Captain Calderon said, well, we took care of him. We fed him. In the original testimony, everybody fed him and did all that, and that was before you saw the video. Yeah, they fed him a bag of chips and 2 bottles of water over a 10-hour period. And then, once they finally get this statement from him, shake his hand, then they go give him the treat. That's when he gets the Whataburger. That's when he gets to eat. But it wasn't until the statement had been made that they then gave him something to eat. It wasn't like Captain Calderon was saying, no, we were feeding him. And he tells him how tired he is and all that. Says, well, good, we'll just leave you here for a couple of hours in the most uncomfortable position. And this charge also has the terminology about extended periods of interrogation. That if you find they violated his rights by wearing him down, by just doing it over an extended period of time, then that is also a reason to find that that statement is involuntary and should not be considered as evidence. The truck parked out there, taking photographs, and they say they had probable cause to search it. If they had probable cause to search it, they had probable cause to get a search warrant. The law says that a person is entitled to the protection of having a detached magistrate, some judicial person, make the decision, is there probable cause to do this search? The law is not set up for the police to decide, well, we got probable cause, so we're searching it. That's only in very rare cases where there are exigent circumstances where there would be a danger to the community if they did not conduct the search at that time. This case, the truck was towed to the sheriff's department and parked, as he said, a carport. And then they're saying, well, we didn't get a search warrant because of the time of day. None of that property was going anywhere. They violated a citizen accused of his rights by failing to obtain a search warrant. These are not technicalities. These are the law. Okay, thank you.
Good afternoon, ladies and gentlemen. I also want to thank you for your attention to this case and for your service. At times I would look over here to you all, and you were all paying and a lot of attention, and you were very attentive. I may repeat some of the things that Mr. Fuchs said because we think they're important, okay? Now, I want to say to you all that we are a nation of laws. the rule of law governs. The law matters. And when we're out in the street walking around, usually it doesn't really hit us like that. But in a courtroom, where a lot is at stake, when a lot of things have happened, this is where the Constitution comes to life. And this is where you give it effect. Not in too many instances do I see that the Constitution is given effect, but for sure in a court of law. Now is the time for you to apply the law to the facts. And Mr. Fuchs mentioned the jury charge. This is the law. And sometimes in here it tells you it's not like, well, I don't like this law, so I'm not going to follow it. As Mr. Fuchs said, you took an oath to follow the law. And I would venture to say that there's not too many times in our lives where we raise our hands and swear to tell the truth and to do the truth and to do the right thing and to follow the law, right? So it must be a very unique situation and a dire and great obligation upon yourselves to follow your oath. And your oath right now is to follow the law. Because you are the judges of the facts. So now it is time to apply the law to the facts. Now, the law applies to all of us, good or bad. It also applies to police officers. It applies to the government, to the state, and maybe even to them to a higher standard because we give them a lot of power. I couldn't come to your house and say, hey, move out of the way, I'm going to search your house. I couldn't come to any of you and say, put your hands behind your back, I'm going to handcuff you. Police officers have a lot of power, and we have to have checks and balances on them because otherwise it gets out of hand, and there's other countries that are police states. Mr. Fuchs mentioned, these are principles that our founding fathers thought about. I'm sure there were horrible crimes and bad things happening back when they were drafting the Constitution, but they didn't say, oh, the Fourth Amendment, your right to privacy, your Fifth Amendment, your right to remain silent, your Sixth Amendment, your right to counsel. Oh, that only applies to good people. That only applies to people that commit small crimes. No, it applies to everybody. Because the day we say, oh, the Fourth Amendment and the right to remain silent, that's a drug dealer. No, I mean, he deserves it. Or that's a burglar of a house, a rapist, whatever. Before you know it, we all lose it. So we need to be careful because of the facts of a case to say, oh, but this laws don't apply to this guy. Because next it's going to be someone else, and it's the slippery slope. Now, I will say this because I want to make sure that you understand at least where we're coming from. We are very, very mindful of the facts, the allegations in this case, the people that got hurt, the people that are deceased. We are very mindful of that. However, even then, the law must be applied fairly. And you have a duty to yourselves because you raised your hand and swore to follow the law. To this judge because he is ordering you to follow the law, and to your country. Regardless of all of us being mindful of the facts of this case. Now, let's start with the burden of proof. The state has the burden of proof. Anything you say, well, did they prove that? You look to them. You don't look to us. They have the full burden of proof, and it's beyond the reasonable doubt. And just to give you an idea of how high it is, beyond the reasonable doubt, there's a standard that they use over as the civil courthouse. It's called preponderance. And preponderance is when it's a lawsuit and people are arguing about money. And so we allow the side that proves things by 51% to win. That's it. Then we have clear and convincing. That's where the state of Texas wants to come and take your kids because they're saying you are not taking care of them or whatever. That's clear and convincing. It's higher than preponderance, which is at 51%. To take your kids, all they need is clear and convincing, and they could take your kids. Beyond the reasonable doubt is higher than that. Why? Because beyond the reasonable doubt, when you convict someone, you're taking their liberty and their freedom. And that's why we've gone to wars. Americans have died for freedom and liberty. So that's why we make it a very high standard, the highest standard in the law. Now, if we start looking at the facts, as Mr. Fuchs said, we'll start, for example, when the charge tells you, Mr. Ortiz chose to remain silent. And the judge in the charge tells you, look, you cannot consider that for any reason. You know, you can't discuss it. You can't say, oh, well, he didn't say his side or anything. Because remember, we don't have any burden, right? So you can't discuss it. It's irrelevant. Why? Because it's not evidence. It didn't come in. What you do decide this case on is evidence that came into that you heard or any exhibits. And so anyone that didn't testify, well, they didn't testify. It's not evidence. If we talk about the idea of the violations of the law, the first one, if you recall, were when Mr. Ortiz was getting arrested. And Deputy Noe Gonzalez was prevented. He was kept from reading Ortiz his rights. And he said, he said maybe Captain Calderon or whatever. And you know, when people get arrested, they have the right to have their rights read to them. You know, and yet a law enforcement officer, and he's military, he knows the Constitution, and he immediately attempted to read Ortiz's rights. And he was prevented from doing that by one of these supervisors. I think he said Calderon. And why? Well, there's the chance that he says, yeah, I don't want to talk. I want to invoke my right to remain silent, or I don't want to say anything, or whatever. Or two, because they want to have the citizen in a controlled environment. Okay? Where they put you in a room, they isolate you, and then it bore fruit here. If we go to the issue of the voluntariness of the statement, what's the first thing? First of all, the state has the burden to prove to you beyond a reasonable doubt that the statement was given voluntarily. And so if any of you have a reasonable doubt, you go, man, I'm not too sure. It's like, you look to them, explain why this. You have the right to do that as citizens, to protect citizens, because you see, the state has a lot of power. The government has a lot of power. Police have a lot of power. And so that's why we have, and our founders thought of that, our forefathers. They said, no, the government wants to take our rights away, your liberty, your freedom. You better be darn sure that it's going to be by a lot of evidence, okay? And so you look to them to say, what about this? What about that? And the law says, look, if a statement is coerced or improper persuasion was used, influence, persistence, long periods of time, duress, promises, and the idea, and it says there, if they say anything along the lines, oh, this can be used for you, what did they tell them about D.A. Alanis being there? And the testimony about Alanis, that he's there on a high profile case in Laredo. And at the time, district attorney, the elected district attorney of Webb County, happens to just be there, and the two chief investigators, one with 29 years experience, Ranger E.J. Salinas, and Captain Calderon, who has about 20 or 25, they say, well, he strolled by, I saw him. It's almost incredulous, because also they testified that when they put him in that room, they kept him. If you remember, he went in at 2:30, and I think they went in at 3:21 or something like that. So that's part of technique. Both Calderon and Ranger Salinas said, look, nothing that happens in an interrogation room is by accident. There's just too much experience on their part. There's too much technique, too much training. They know what they're doing. It's by design. And of course, when you say, oh, well, yeah, but you were icing him or you were making him sweat. Oh, no, I was busy doing other things. You know, they're trained in how to answer. You know, they go to school on testifying, how to testify. Not lay witnesses, but cops do. And so, it could be, well, I was doing something else. Maybe he was watching the monitor, watching the guy sweat. That could be one of them. And so if we keep on going on that, this combined experience, when Salinas walks in and he says, starts talking, he says, "Are you willing to give us your side or your statement?" Ortiz responds, "No." Now, I don't know how it comes that they say, a police officer say, "Oh, I didn't take it," like he was trying to say he wanted to remain silent. What did the young lady just say? Use your common sense. I go up to someone, "Hey, you want to dance?" "No." "Well, let me talk to you about the technique I have in dancing." No means no. "Hey, can I borrow some money from you?" "No." That's it. "Can I take your car?" "No." No, it's no. Except here. Except here, it's not no. Because the cops say, "Oh, I didn't interpret it that way." If you follow that reasoning, that they didn't, because the cop, remember, we're supposed to be looking at the accused, and did he invoke his right? Yes, he did. No. When asked directly, "Are you willing to give a statement?" No. And then the cops turn it around, "Well, I didn't take it like that." Their state of mind. Follow that logic. What about the next guy? "I want to take the Fifth." "Well, I didn't take it like that because he didn't say the Fifth Amendment." Go further. Another guy says, "I want the Fifth Amendment." "Well, I didn't take it like that because he didn't say he invoked the Fifth Amendment." So if you follow that logic, they can interpret it any way you want. And then the citizen that's trying to say, "I don't want to talk to you," let's say he said, "I don't want to talk to you." Oh, well, he was being impulsive. We wanted them to think about it. Their interpretation should not be the measure. It should be, what did the citizen say? If he's asked, does he want to talk, and he says no, that's it. There's no magic word that is required under the law that says you have to say, "I invoke the Fifth Amendment of the United States Constitution." Use your common sense. And I submit to you that minute, that should be enough for you to say, the guy invoked his Fifth Amendment right to remain silent. He was asked directly. He answered directly. This judge is telling me if he invoked his rights, I cannot consider that statement. I have to wholly disregard it. And it's not evidence in this trial. If you use your common sense like you would anywhere else, at the store, at the cafe, anywhere. But in this court of law, because Ranger Salinas and Trooper Calderon say, "Oh, we didn't take it like that. We still have to read him his rights." No, there's no such thing. There's no law that says I still have to read him his rights. That was it. But if that's not enough for you, let's keep going. The police become aware during the questioning that, because they had the information from Erica, that they'd been out drinking and then she was doing the drugs and all that. And when they have the truck, they see the three tall boys, remember? Then they see in the video that he bought another three tall boys. So he had been drinking tallies before, as they call them, and tallies now. And they also, and no one disputed this, everybody knows he was taking all these pills from the VA. No one disputed that. So this guy is medicated, he's been drinking heavily, and they know his emotional condition and mental health condition is not the best. But they don't stop. They keep on going. Okay? Now, if you look at then the technique that they're using, now, because he is not cooperating, which could be interpreted by any one of you as saying he wants to terminate the interview, okay? You can interpret it like that. Nothing stops you from that. They start confronting him with evidence. They start saying, "Hey, Erica said this." They start confronting him with items from the truck. Remember, they brought in the purses and the syringes. They confront him with the rounds and the pistol. "Hey, how come you don't have?" So they're trying to give him incriminating evidence, okay? Knowing that he's been drinking, he's not in his best state of mind. They confront him with the victim's photos. And then they again ice him. They leave him to sweat there. and leave them over a long period of time, like the charge tells you that could be a violation. Finally, they enter at 10:55. Okay. Now it's been maybe 7 hours, 8, something like that, and they've given them what? Water and chips. Now, this is where we're talking about, and the charge will tell you, and it's the judge's charge. He's telling you, look, if there's improper inducement, then it's not a voluntary statement. Now, what do? First is hey, we want to put in a good word with you for the DA. If you cooperate. There were a lot of ifs in there. Help us, and we'll help you. We will get the picture. We won't. Everything's in the future, you see. Everything's in the future. It's conditional. Cooperate. Talk to us. Everything is conditional. It hasn't happened yet. And like I told one of the rangers, why don't you just say no? Say no. We're going to do what we need to do to get into the house. No, we don't give a damn about your picture. And the retirement is very important, the retirement. Oh, I think it was Calderon, was falling out of his chair trying to convince him, please, we can do it. She shouldn't be left without retirement. I'm going to work on it. I'm telling you, she deserves it. Please, please, please. But it's conditional. Give us this. When he talks about isolation, being placed in isolation, that also, I don't know which of I don't recall right now, but it was Ranger Salinas said, yeah, but you want an isolation, but you're not what? You're not talking to us. Now, whether they wanted him to tell the truth or not, it's not the question. They wanted him to talk. Okay? And the fact of who brought it up is irrelevant. What does it matter who brought it up? You see? What does it matter? It doesn't matter who brought it up. It's still an inducement. Once they know, they can induce him to do something if he gets that. What if they say, well, we'll get you your toolbox? Well, maybe that's not important to him, but the picture was important. Once they learned the picture was important, they started utilizing it as inducement. Okay? Now, at some point, after all this improper inducement, after all this time has passed, no true food, just water, understanding and knowing that he's got this emotional, mental health issues, the drinking, whatever the case might be going, he finally does start making incriminating statements. Okay? So, we submit to you that if you look at the totality, now, I saw his qualifications that they put up there. Yeah, that's his normal self. Military, masters, all that. But you got to look at the guy that's in front of you. You know, you have to look at the guy that's in front of you, that was there at that time. Broken, PTSD, migraine headaches, insomnia, nightmares. That's the guy that was in front of them. And they induced him. They confronted him with all this stuff. They promised him things. The DA, all that. It was improper inducement. And if you read the charge, it's very clear. If you coerce the individual, if you place him under duress, at some point it passes that threshold, and it did here, ladies and gentlemen. It passed the threshold where he involuntarily gave that statement. And the court instructs you that because he was improperly induced, because he was given these promises, it says you must wholly disregard that entire statement. You literally have to take it out of your head like it didn't happen. You know, and for any one of us that go, well, come on, a picture. Because the DA asked him at the very beginning, did you promise him probation? Did you promise him that you would dismiss the charges? Look, he's been there X amount of hours. He's all distraught. He's tied down. It's like you have a dog tied down that hasn't been eating or whatever. You know, you want him to roll over? You don't need to give him a ribeye. You just give him a Scooby snack. That's enough, and he'll roll over. You don't need a lot of promises when you have someone in that condition. Because he's talking about totally different things. And so I submit to you that the statement was not voluntary. They overcame his free will, and under your oath, this is not a popularity contest. It's not because you like it. It's not because you don't. It's not your fault that the police used those tactics, excessive tactics. It's not your fault. Under your oath, you have to disregard that statement because it was given involuntary. Not to mention the very beginning, are you willing to give us a statement? No. That should be, in my opinion, enough for any of you to say, this guy invoked his Fifth Amendment right off the bat. And this judge is telling me I must disregard it. Now, regarding illegally obtained statements, the charge talks about that there's a lot of laws, that talk about privacy. It's the Fourth Amendment, first of all, your right to privacy, your right to be free of search and seizure in your home, in your person, in your possessions. We have Article 1 of the Texas Constitution says the same thing. There's another section in the Code of Criminal Procedure says, 3823 says, any illegally obtained evidence, you cannot use it against an individual. Now, let's look at what happened in this case. These rights, again, that I'm speaking of, are all of ours, okay? And rights are not like privileges. For example, your driver's license, that's a privilege. The state, you don't really have a right to drive on the highways and the streets and the beaches of the state of Texas. The state of Texas says, oh, okay, you met these qualifications, we're going to give you this driver's license. But rights are yours. They're inherently yours. No one can take them away, okay? And so, again, you have the Fourth Amendment and the United States Constitution, the Fifth Amendment. Now, what does it talk about? Seizure of property and search of property. And it does talk about, again, like I said, in your person, cops, it's like, hey, get against the wall, I'm going to pat you down. Let me search into your pockets. Your home, hey, open the door. Let me walk in. I want to look what's inside. And any other possession, I don't know if it's a go-kart or a car or your motorcycle. You have a privacy interest in there. Now, when the trooper, Obregon, I think, asked him, is this your truck? He said yes. I'm going to give you an example because they're talking about abandonment. This is more what abandonment is under the law. A guy with a bag at the airport puts it down, and it's got 100.
This is not an evidence. Giving hypotheticals, giving examples, not permitted.
In reference to the law, even as Mr. Perez said, the law is included in the instructions
Yes.
and the jury charge has been given to you.
Yes.
And anything that's not consistent with that shall be disregarded.
Yeah, just because they call it abandonment here, I can tell you any other thing about what I think abandonment is. Abandonment is when you put down a bag, it has $100,000 in cash, and the DEA shows up, hey, we know there's money in that, in cash, $100,000 in cash in that bag. Is that your bag? Oh, no. Even if he did have it, okay, he put it down. And is that your bag? No, that's not my bag. That's abandonment. He said, that's my truck. Yes. He asserted his interest in that truck and his privacy in that truck. Having said that, what does Ranger Salinas do? He immediately calls Santuro and says, secure the truck. That means it's seized. Okay, if you're walking down the sidewalk and the cop says, stop, you are seized. He doesn't have to come and grab you. For Fourth Amendment purposes, under the law, you are seized the minute you're commanded to stay somewhere. Okay? No, nothing you don't have to be manipulated or anything. The minute you're told to stay or not move, you're seized. The minute he told Santuro, secure that truck was seized. It was under law enforcement possession at that moment in time. Okay? Now, let's talk about exigent circumstances because it's important. Okay, exigent, what does it mean? Immediate, urgent, pressing, pressing circumstances, immediate circumstances. Now, why is that relevant to vehicles? Because vehicles can drive away. So If the cops are looking for some evidence in the car and they go, hey man, we need a search warrant for this car, and the guy comes over, like, hey, I'm going to go to McDonald's, and he starts driving away, that's exigent circumstances. No. We need to search it because there's exigent circumstances. You could drive away. That's one way to search a vehicle when it's not possessed. But once it's secure, the exigent circumstances go away. And that car, for all practical purposes, is like your home. Your home can't drive away. That car, now that it's secure, it can't drive away. And I told Ranger Salinas, could a guy go in and say, hey, let me get into his truck and start driving away? Once Santuro was told to secure it, he said no. We know the vehicle is seized for Fourth Amendment purposes that all of us have, okay? Now, then comes Ranger Salinas. He says he arrives at 1:30. By 1:34, he says, I'm taking pictures. Now, there's two things, two ways on a vehicle like that where you're going to look at stuff. Well, there's the third one, but it's not really that what we're talking about. The plain view, okay? I brought up plain view. Plain view is your car is stopped at an HEB, right? I could walk by your car and say, oh, what's inside this car? Oh, man, she's got a couple of Snickers bars and, ooh, look at that popcorn. That looks really good. I could see inside your car and look at whatever. I can't touch it. I can't manipulate it. I can't open your door, but I can look. That's plain view. That's okay. What does Ranger Salinas do? And it's on that video. He's shown his slide in there, and he saw the holster. Okay? Then he goes, and we have the pictures, starts opening doors and taking pictures and looking. A search isn't like, well, I have to grab it. No, a search is observing. You know? It's like if I go to your house and I open your intimate clothing drawer and I open it, I don't touch. Am I searching by looking? Yes, I'm searching. I don't need to be grabbing stuff. There's a search. The minute they open the doors, that truck is being searched. And he did it because he saw the holster. And he told you, officer safety. So he has to call and tell him about the holster. But he wants to know, is the gun in the truck? And it's incredulous. It's really beyond believability that this guy, Ranger Salinas, 29 years, that he would come and testify to you that he saw it yesterday or this week on a video, finally saw the gun. That's the first thing he was looking for, the gun. Now, why wouldn't he come clean about that? Because, Judge, can you give me like a 10-minute warning? Because he's stuck. Santuro said no inventory search was done. There's only two things you can do, inventory or search. This deal about preservation photos, what the heck is that? There's no such thing in the law about, oh, we did a preservation search. There's no such thing as a preservation search. It doesn't exist. It's either inventory or search. And when they said no inventory, they're stuck with the search. And you know, she asked them at some point, oh, but you only saw things in plain view? Bull. I had to come back and say, wait a minute, was that gun in plain view? The things in the fender and the doorwell, are they in plain view? And all of us have cars. You know you put stuff down here on the doors. That's not in plain view because it's between the seat and the door when it's closed. Now he's observing things that were not in plain view. Therefore, what? It's a search. At some point he said, I asked him, did you manipulate the vehicle? No, I did not manipulate the vehicle. And the DA, and you were only seeing things in plain, it was a dogfight. It was pulling teeth. Now, if they're saying they have a right to search it there, then what's the big deal? Why fight so hard if they're saying, oh, we had probable cause to search. We could have searched it there if we wanted to. You can't have it both ways. You can't fight a tooth and nail that, we could have searched it, like they're going to claim we could have searched it out there. It was abandoned and all that stuff. Then why fight so hard? Because they know it was a search, it was warrantless, it was illegal. And once you have an illegal search, that's it. All that you cannot consider, including the gun. And so they're stuck with this search that was illegal because now nothing can be considered thereafter. Because we know it wasn't an inventory search because Santuro signed, there was no inventory. And Ranger Salinas, because of that form, was stuck. He had to say, no, it wasn't an inventory search. So they came up with this in-between BS. Oh, it's a preservation search, pictures, whatever. I guarantee you there's nothing like that exists in the law. Now, if we go further from that, we know further that the truck is secure anyway because Ranger Salinas says secure and follow the truck when the record picks it up and takes it to the police station. We know the record drivers are going to pull over and start taking stuff, right? The truck is secure. It already is anyway, and it's already been searched. Now they take it to the station, and that's where now they're starting the interrogation and the like, right? So we know that at 2:30 is when they put Ortiz into the interrogation room. We know that around 3:21 is when they walk in to start interrogating. And we know that at 3:54, Ranger Salinas instructed CSI Ugarte to start searching the vehicle. So 2:30, Ortiz in the interrogation room. 3:21, they walk into the interrogation room. 3:54, start searching the truck. Now, I asked Sergeant Salinas, well, is it in a secure area? Could I have walked into the substation and just driven away? No. Is it some sort of chain link fence or whatever? I know it's not a bank vault, I told him, because he was like, well, it's kind of relative. I know it's not a bank vault, but, you know, it has to be somewhere where not you and I could not just walk in and take it. And so he said, yes, it's in a secure area. Okay. No exigent circumstances. We know it's not going to drive away. It's like a house now. What else a cop should do? Get a warrant to get into the truck. Now, what does Salinas do? You see, he got ahead of himself, is what happened. And now they're stuck with that. There's no way of undoing that. He got ahead of himself. Because what he wanted to do is when Ortiz was not cooperating, and it's, again, both Calderon and Salinas said nothing happens by accident in an interrogation room. These are very experienced investigators. What does he do? One of the tactics is go and confront the guy with incriminating evidence. Well, where was the incriminating evidence? Where was it? In the truck. Oh, man, by the time I get a search warrant, just search it. So they go and they do an illegal warrantless search. And then they come and confront Ortiz with this. We know this is not your wife's purse. Why? Look at this purse. It's pink, and we know. And look, there's condoms here. Those aren't your wife's condoms. And look at the syringes. Those aren't your wife's syringes. And they also took the gun out. The gun that supposedly a 29-year law enforcement officer, elite of the elite ranger, had not seen it when he takes a picture of it. They get the gun, and they, again, manipulate the gun because they take out the I don't know if you know how guns work, but on a semi-auto, it has a clip, and from the butt, a magazine comes out, and that's where it has all the bullets. It's not like a revolver where it goes like that. So either way, they take out the magazine and they count the bullets, again, because they want to incriminate him to see if he'll talk. They go, hey, man, look, you got missing bullets. When's the last? Oh, because they had asked him before, when's the last time you shot your gun? They locked him into that. Last summer or whatever. And okay, well, why are you missing bullets from your magazine? He needed that evidence right then and there, so he got ahead of himself. but now they're stuck. You know, I asked Ranger Salinas, did you have time to get the warrant? Yes. If you had wanted to, could you go get a warrant? Yes. Nothing prevented you from getting a warrant? No. He just got ahead of himself. Because in the end, he didn't obtain that search warrant. And so, on that issue, and remember, anything that you go, even if you go back to the, hey, yeah, why when the ranger came in and said, are you willing to give a statement? And the guy said no very clearly. I have a doubt, it's causing me to question that the guy invoked his right, I think he invoked his Fifth Amendment right to remain silent. You know who has to explain that away to you? Them, the state. Hey, why didn't they get a warrant? Oh, it was abandoned. No. Did he say, like the guy with the bag? No, that's not my bag. Did he say that? No, he said, that's my truck. And where are the keys? Think about that. Where are the keys? Why open the doors? Ask them all those questions. Why open the doors? If they're not going to search, and we know it's not an inventory, and there's no such thing as preservation search, okay? Those are all doubts that you should say, these are, I'm not telling you a Martian opened the door of the truck. These are all reasonable questions that common sense people should be asking. And then if you have a reasonable doubt, and you say, I have a doubt. Remember beyond the reasonable doubt she said about the Mount Everest? That's kind of the convincing nature of evidence. They have to take you from probable cause to preponderance halfway up the mountain, to clear and convincing where they could take your kids, to preponderance of to beyond the reasonable doubt. They have the duty to do that. And she said, we gladly accept that. Well, explain all this away. Why not get a search warrant? And so with regards to all the evidence that came out of the truck, I submit to you that the state has failed to prove to you beyond the reasonable doubt that they legally obtained that. And we have laws, like I said, the Fourth Amendment, the Fifth Amendment, Article 1 of the Texas Constitution, 3823 of the CCP, all those say, look, mostly get a warrant. There's few exceptions to warrantless because we want a neutral magistrate. Okay, just the idea of warrants. You know why we demand warrants?
I'm going to object now this line of argument, Your Honor. He's now getting into explaining the law.
Be consistent with what the jury instructions are.
Yes, well, look, a warrant is because you want a neutral magistrate to review the police conduct. So let's say they say, hey, we want to search that woman's truck because she's a redhead. Here, Judge, we want to search. Well, no, that's not good enough. You see, we want someone that's detached, a neutral magistrate, to check the police conduct. Otherwise, they just get warrants on their own and, go do warrantless searches like in this case. So that's why we demand mostly warrants. Again, so for those two reasons, and the judge is instructing you that if you believe that the state failed to convince you beyond a reasonable doubt and you have reasonable questions, then you should say this evidence was illegally obtained and this judge is ordering me not to consider it. And that means the gun, that means the bullets, that means the case, well, everything that was in the truck. Okay? It's telling you don't consider it. Yes, Your Honor. Now, the way the charge reads, it talks about, and I also find that this offenses happened. Now I'm getting away from the evidence, okay, the facts and the like. Now I'm explaining how you would reach a conclusion. And so the first thing that the charge talks about is, if you find that the defendant, beyond a reasonable doubt, did this killing, this killing, and this killing, and this killing, and it was all part of a common scheme and plan, then you shall find them guilty of capital murder. But remember, to get there, you would first have to decide that the statement was voluntary, and I have no reasonable questions about it, no reasonable concerns, no reasonable common sense hesitation. And you would also have to decide that you have no reasonable questions about the search of the truck, no reasonable doubts. And the charge tells you that the state has the burden of eliminating and excluding all reasonable doubt. Not 50%, not 80%, it says all. They have the duty of excluding 100% of any doubts that you might have that are reasonable. Hold them to that standard, please. Now, when we get back to the charge that I'm just talking about, at the end it says something along the lines of, if you believe it was in the common scheme, course of conduct. Now, the question may arise, well, in the state of mind that Mr. Ortiz was during that time, did he really have the mental capacity, regardless of what he said, okay, to really form that intent?
I'm going to object. There's no evidence of this, Your Honor, and this is improper argument.
The jury is aware of what the evidence is. This is just closing arguments. Go ahead and continue, sir.
Yeah, you heard the evidence, but the state has to prove to you that he had the state of mind in the situation that he has that was not disputed, that he's taking, from February of 2018, this young man had an impeccable record, had served our country in Iraq, had seen horrible things in Iraq. They called him Doc. He saved lives over there. He came over here. He became a Border Patrol agent, was impeccable record, immediately rose up to the intelligence unit. Come February of 21, migraines, nightmares, post-traumatic, insomnia. And then all hell breaks loose from February of 2018 to September of 2018. I think you have the right to say, hey man, was this guy really had the ability? Was it really that he wanted? Regardless of what he stated, was it really a common scheme and plan? Did he have the capacity to do that? You have to decide. That guy, and then all these pills, and everything that happened at the VA, all because he couldn't find a primary doctor in Laredo because he had the primary in San Antonio. You really have to ask yourself, is this guy really a serial killer? Or did these things mess him up so much that no, he didn't have that capacity? And if you find that the state fails to prove to you that he did not have that capacity, then the charge tells you, now consider, because then if that's the conviction, then it's life without parole. If that's the conviction, life without parole. Okay, Your Honor. And so then you can consider murder. And you can say, well, I think the state proved to me that he was committing murders, but he didn't have the capacity to form this common scheme and plan because he was so messed up. And so you can convict him of individual murders. Okay? And I would submit to you that given the evidence that we have of who this young man was, like I said, almost a war hero, a lifesaver, a law enforcement officer, protector of our rights, to suddenly, after he starts taking these pills in February of 2018, to become this. Is this guy really a serial killer? And you have the right to say, I don't think you proved that beyond a reasonable doubt. I just have questions about that I'm sorry, I can't do that. You have it within your power. And if you decide no, then you do, and you have the right to then say, but I will consider him of murder for killing these women individually. And I submit to you that based on that history, as opposed to a guy that, at 14 carried guns at school, and then at 18 raped a girl, and at 22 he did an aggravated robbery, and then a guy that has the history and then graduates to serial killer, okay, that's a very different situation. I am telling you this is a very unique situation, and that this young man is not a serial killer in the sense of the law. And so I'm asking you that if for any reason I have failed in informing you, if you will, that the evidence of the truck should not be considered. Literally, it's like putting Jack in the box back in the box, you know, or that his statement is voluntary. Then please consider the other one, where it's individual murders and not serial killing, considering his history and his service to our country. I will still say that based on how I started this discussion with you, how I began, that because we are a nation of laws, and because we are and governed, and we accept that, the rule of law, that the behavior and the conduct of the police officers, regardless of what you might think about Mr. Ortiz, based on your oath, you should exclude all the evidence of the statement, because in fact, it violated his rights. No matter, remember what I told you about our founding fathers, they didn't say, oh, these rights are for good people only, okay? And if your oath is, if you're true to your oath, and only you will know if you're being honest to yourself, true to yourselves, that when you raised that hand, you said, I'm going to follow this oath and rule on the law. I submit to you that based on what you have in front of you, they violated his rights by not accepting the no. That should be it, as clear as day. And then they violated his rights by all this duress. Like I said, it wasn't the ribeye. You know, they weren't offering him dismissals and the like. But he was tied up. And anything that came in from his statement, you should say, I'm not going to consider that as evidence. Because that's what this judge is telling me, if the state failed to convince me beyond a reasonable doubt. And all the evidence that they got from that truck, because they searched it illegally twice, you should say, I'm not going to consider any evidence because they failed. The police are the ones that did these things wrong. They failed to convince me beyond a reasonable doubt. I have reasonable questions. And without that evidence, you should return a verdict of not guilty. Thank you all for listening to me, and I appreciate your time.
All right. Again, the state reserved 46 minutes for rebuttal.
May it please the court, counsel, ladies and gentlemen of the jury. Mr. Perez comes up here and he asks, is Mr. Ortiz a serial killer? I'll answer that question. Mr. Ortiz was a serial killer then, and he's a serial killer now. And that is what the evidence has proven. This is not the law according to Perez and Fuchs. Everything that he came and told you here was by design. Using his words to manipulate and induce the evidence. Look at your jury instructions. Nowhere in the jury instructions does the word warrant appear. But he came up here and said it maybe 75 times, according to him. It's right here, and I'll ask you to please turn to page 14 and follow along. on section 17. The state must prove beyond a reasonable doubt that the evidence was not obtained in violation of the law. Now, therefore, if you find beyond a reasonable doubt that the defendant abandoned his white truck, I'll give you an example. Somebody robs a bank. Somebody's smuggling aliens. They're going down the highway. They ditch the car. They bail out. They run. They're abandoning that vehicle. It's free game. In the commission of offense. In the commission of an offense. That's what Juan David Ortiz was doing. He ran from Trooper John Henry Bradshaw, and he ran from Trooper Abel Obregon. He never had any intent to come back and claim ownership of that truck. Manipulation. That is what the defense is doing. They are moving the facts and evidence around to hide the ball. Stay focused. Ms. Rios told you, and I told you during jury selection that you need to stay focused. Because you know why? Nobody is above the law. And nobody is below the law. Nobody's below the law. These four women are entitled to their rights. But yet he wants extra protections for Mr. Juan David Ortiz. All of his rights were preserved. All of his rights were protected. It's incredulous for him to come here and stand here and interject notions of law that don't apply in this case.
Objection, Your Honor. Objection, Your Honor. Striking at the defendant over counsel's shoulder, Your Honor.
He opened the door, Your Honor.
Just again, these are closing arguments. The jury's been instructed as to what the law is, and the jury will remember what the facts are and overruled.
Comment on the defendant's right to remain silent, Your Honor.
Overruled.
Now, therefore, if you find beyond a reasonable doubt that the defendant abandoned his white truck, yes, there's a mountain of evidence that he abandoned the white truck. You saw the video. What did I tell you in opening statements? I said we were going to take you to Webb County, Laredo, Texas, on the day of September the 14th of 2018 and show you. We're just going to come up here and tell you. We showed you. We took you there with all the technology. And you saw his actions. He abandoned the truck. He abandoned the expectation of privacy in that truck. And everything in that truck was free game. No warrant required. The word warrant's not even in here. In the instructions the judge gives you. Smoke screens, rabbit trails. That's all they come here and give you. Stay focused. Now, therefore, if you find beyond a reasonable doubt that, number two, that the officer searched the truck at the Stripes and or the Webb County Sheriff's Office pursuant to a valid inventory search. Once the truck was abandoned, the search was legal. You can take that to the bank. You could go home and sleep tonight comfortably knowing that that was a legal search. And finally, if you don't want to use number two, because you could use one, which applies. You could use two, which applies. Or if you don't want to use those, you could use number three. The searching officer had probable cause to search the truck at the Stripes and or the Webb County Sheriff's Office. What did Ranger E.J. Salinas tell you when he was pressed and under the questioning? He said, I had probable cause. What was the probable cause? We were all here for the last week and a half. The probable cause was the aggravated assault that he committed on Erica. Pointing the gun at Erica's head. Attempting to restrain Erica against her will. If that's not probable cause, I don't know what is. But it's there. And nowhere does it say that they needed to go get a warrant. Stay focused, ladies and gentlemen. Stay focused. We'll talk about the voluntariness of the confession. What did I tell you in opening statements? I said that you will be able to see, hear, and analyze the confession. That video is the best evidence. To use Mr. Perez's word, that's the best evidence. It is the best evidence. And when you see the video and you put everything into context, Ranger Salinas was not asking Mr. Ortiz to go out and dance there in the hallway at the police station. We had 4 murders. Like Captain Calderon said, you have to put things into context. And Juan David Ortiz never exercised his right to terminate that interview. This is no ordinary citizen. You can't have it both ways, Mr. Perez. This is a law enforcement officer. Look at the totality, like he said. Look at the totality of the interview and all the facts that Captain Calderon and Ranger E.J. Salinas had. And you will know when you use your common sense. You will know when you use your life experiences. And you will know, most importantly, when you follow the law, according to the judge, not to Mr. Perez or Fuchs, that was a legal confession by a high-ranking law enforcement officer who had executed arrests, 9-year veteran in the Border Intelligence Center. Watch it, listen to it, look for it, and you will never see him ask for an attorney. You will never see him terminate the interview. What will you see him do? You will see him lie, lie, and lie, and lie. And like I said in opening statements, he took that first word, blackouts, and he ran with it. Interviews are cat and mouse. Interviews take technique. There's a lot going on there, but nothing illegal. Captain Calderon and Ranger E.J. Salinas were professional. They never coerced him. They never intimidated him. They never even used the word promise. The only word they used was permission. And like my co-counsel stated, the initiation of accommodation was Ortiz. Can you get me this? Can you get me that? Can you do this? Can you do that? It's a two-way street. There was no inducement. Remember what I said in opening. This is a high-profile case. The entire town of Laredo, Texas was scared. These crimes were happening. Law enforcement was there. Law enforcement converged in the observation room to see what was going on. Why? Because we care. We care. Just like you care. Look at the demeanor. Look at the descriptions. Look at the choice of words. And what do you see? You see a man, Juan David Ortiz, trying to manipulate two experienced law enforcement officers who are armed with evidence. They are armed with information. They are armed with facts. And his facts aren't checking out. There was never any mental breakdown. How do we know that? Starting in this 6 and this 7, when he starts to cooperate, you remember, he himself reveals that everything at this 1, 2, and 3, I don't know. I don't know what the fuck you're talking about. I don't know her. Crumbling the papers, throwing them to the side. All of that he himself revealed was a lie. It was a lie. With all of the facts that finally he comes around with whatever little semblance, little grain of sand, of some form of decency that the agents were able to find, that he confessed. You saw it. Can you take off my handcuffs? Just like I told you in opening. Can you take off the handcuffs? I did it. I did it. I've disgraced the uniform. I've disgraced the country. I've disgraced the blue. Those were his words. They're not my words. Those were his words. What did I say in opening? He betrayed the badge. He betrayed his family. He betrayed his community for his own selfish needs. Use your common sense. This was going on for a long time. If Erica knew him for 5 months, and she had seen him previously with Melissa, he was living this life much longer than 5 months. But the walls closed in. When he decided that he had enough, what did I say in opening? He played judge, jury, and executioner. I got off the truck and took her out. Just like that. Cold, callous, calculating. Just like that. You know what's incredulous? For him to sit there and say, well, then I went home, took a shower to my lovely wife and my kids, and I went to work the next morning. Wow. That is incredulous. That is shocking. That is shocking. And it is terrifying. It is terrifying to have the enemy within the ranks of law enforcement. He knew it. He did disgrace the uniform. He did disgrace his country. He did disgrace the blue. But that's not all he said. That's not all he said. In his own words, the monster comes out of me. They are turds. Mierda in Spanish. They are dirty. Why doesn't anyone take out these bitches? I wanted to clean up the streets. I grabbed it by the horns. What did he say about Claudine? Pay attention. He said, with this one, there was no paranoia. With this one, there was no paranoia. All the other bitches, I took them to 35 North, and I'll keep cleaning up the streets. And at one time, he says, I'm like, fuck, let's go do it again. And he was going to keep doing it if it wasn't for one person. And who was that person? Who is our hero in this case? Who did we put on first? With all of her flaws, with all of her defects, who did we bring you? Erica. Erica Pena. She came here and she broke the case on September the 14th, 2018, when she escaped. She revealed the 5-month relationship that she had. She saw these with Ramirez. She led to law enforcement right to his doorstep. And most importantly of all, like my co-counsel stated, she testified truthfully. She had nothing to gain in coming here to testify other than to tell the truth. She was put under rigorous cross-examination. That is the purpose of questioning witnesses so vigorously and so personally. And she admitted all of her flaws. But she made the connection. She was the key to breaking open this case. There was no doubt that on September the 14th, when she came here and testified, that back then in 2018, when she went out to that bus stop, that she had been laying low and she was scared. All of the women that were working in that area were scared. They were scared because two of their friends had died. Remember, Melissa Ramirez on September the 3rd of 2018, and Claudine Luera on September the 3rd of 2018. I would submit, and Mr. Perez, Mr. Fuchs, yes, they're here for Juan David Ortiz. But who else are we here for? Who else are we here for? We're here for Melissa Ramirez. Melissa Ramirez is gone. Her life was ended early because Juan David Ortiz decided it was time to take her off of this earth. Took her from her family, took her from her friends. Nobody has the right to do that, ladies and gentlemen. She was not a perfect human being, but none of us are. And everyone is entitled to the protection of the law. We're here for Claudine Luera. One gunshot wound to the back of her head. Remember I told you in opening that we would take you back to those horrific moments right before they died? You see, every moment has a story, has a theory. We will go into that shortly as to what happened in those last seconds. Those last seconds before this self-proclaimed monster put a bullet in the back of her head. We're here for her. We're here for Griselda Cantu. Shot twice and beaten almost beyond recognition. Blunt force trauma. Again, by the same self-proclaimed monster that said he didn't want to hear her talk about the Lord. He didn't want forgiveness. He told her, San Antonio is that way, Laredo's that way. Get walking. And when she made that fateful turn to come back to his truck, he decided, I'm taking this bitch out. And leaves her in the street. We're here for her. And finally, Janelle Ortiz. We're here for Janelle Ortiz, who in his confession, he's so obnoxious. He says, I didn't even know that one. I thought she was going to put up a fight. She asked me, are you going to kill me? Yeah. Get off the truck. The only one that didn't put up a fight, as he put one .40 caliber Smith & Wesson hollow point in the back of her head. And what does he do? The evidence showed. Went back to San Bernardo. Thank God that the bolo was out and that Trooper Bradshaw had his head on a swivel and was able to spot the truck. Imagine for a second what else was going to happen after he came out of that restroom and continued to hunt. He was on the hunt.
Objection, Your Honor. Not in evidence.
Again, the jury knows what the evidence is.
So what I want you to do, and I'll ask you and I'll plead for you, that when you go into the jury room, put these pictures up. First thing, put these pictures up on the wall, on the side. Because that's what we're here for. For these 4 victims. They will guide you through the evidence that was obtained from their bodies in placing Ortiz at the crime scene. They spoke. He tried to silence them. But the science doesn't lie. Right? Remember what Daniel said? The science doesn't lie. And it was the science taken from some of these victims' bodies that puts Ortiz there as the killer.
Nomás. Ponte aquí nomás, deja hablarle. Ok, nomás ponte de este lado, please. Es que tengo que agarrar algo de ahí. Ponte aquí nomás, real quick. Ahorita te ayudo. Just tranquila. Ponte aquí, mira. Let me just get something from you.
No me vaya a ver.
No, no lo voy a ver, no lo estoy viendo.
Me asusté bastante.
Alright. ¿Y dónde está el muchacho?
Trae una troca blanca.
¿Ya se fue?
Sí. Ay, me asusté bastante, sir. Sir.
Okay, just hold on, okay?
Me quiero sentar.
¿Quieres file un report?
Tengo miedo que me vaya a ver. Me quiero sentar, sir.
Hey, this is 3215. Can you send PD to my 20? I'm right here at the Circle K on McPherson and in Loop 20. It's in reference to an assault on a female. You know which one, right? The Valero, right here at the intersection of Loop 20 and McPherson, like going towards the Border Patrol station. Okay, let me. Yeah, I'm waiting here with the female. Alright, thanks.
Tengo miedo, me puedo sentar ahí, sir.
Espérate. Oye, entonces, nomás tengo que saber algo. Entonces, ¿tú te subiste a la troca de un muchacho?
Yo me subí, sí. Él ofreció comprarme cigarros y compró unas beers. Y dijo, ¿vas a dar la vuelta conmigo? Y yo le dije que sí, sir. Nomás que yo nunca me voy lejos, o hay notice de que él estaba manejando muy para acá. Y le dije...
¿Y dónde estaba el muchacho? ¿Este side? Ahí donde está la troca, es esta y el carro.
Allá, está el trailer. Ay, sir, me quiero sentar.
So cuando yo estaba aquí, ¿estabas adentro de la troca?
Sí, me vine corriendo, me sacó la pistola y me quería subir y me empecé a gritar, help me, help me.
Hyperventilating, panicking, terrified, she broke open the case, giving law enforcement the probable cause to go and look for Ortiz. This started way before the stripes, ladies and gentlemen, and it was this young lady's courage and her will to live that made his arrest possible. And sometimes when you have the video, this is Trooper Hernandez's video, his body cam, and you'll have the chance to go and study it. But sometimes when you study things a little bit deeper, you find more out. We know that his home was on Burr Oak, but listen to what she says when she's trying to remember some of the streets around the area.
But she knows that guy's name, like the first name and where he lives, though. Well, just the first name, David. And Yeah.
Que más o menos vive por aquí.
Y vive por una casa que se llama, ¿cómo se llama la calle? No, nomás dime qué calle
Es
es.
aquí como por San Isidro.
Por
It's a
San
big
Isidro,
house.
it's a big house. Por Sand Hill or something like that, right?
Es una calle, más o menos
Sand Hill, I think that's what it is.
C-H-A-O-S.
I'm right here in McPherson and Luke 20.
C-H-A-O-S. Where she got that, how she got that, we will never know. But listen to that video. And in her mind, and in her moment of panic, she spells chaos. She spells chaos. The chaos being created by that man who's sitting over there, Juan David Ortiz. Study the videos, study the demeanor, and you will see, and you will be convinced beyond a reasonable doubt that this mountain of evidence, that we have reached it, and we have kept our promises, improving the scheme, improving the crime, and proving his guilt beyond a reasonable doubt. Troopers Bradshaw and Obregon, let's follow the story. They were the ones that spotted him, and you saw the video. Don't take our word for it. We showed you, right, when they pulled up. You heard the orders by Bradshaw. They were clear. Then, Trooper Obregon takes over, giving his commands. And what does Ortiz do? He runs away. He evades law enforcement. The timeline. He's spotted at 1 a.m. He runs away from the troopers. He abandons his truck. He hides at the Ava Hotel, and he's captured at 2:30. And what I told you in opening statements since the time of his arrest, and you heard it. You heard when he said, "Now's your time." You can play it back. He says, "Now's your time. Take your trophy pick." And what did the veteran Noe Gonzalez, the SWAT guy, say? When another veteran asks this veteran, "Hey, take your trophy shot." What was the response? "We're not about that, bro. We're not about that." And they treated him with dignity and respect. The confession. They've come up here again and tried to put up these smoke screens to get you to think that confession was not legally obtained. We know it started at 3:20. They are investigating 4 murders and an aggravated assault. They're armed with information. Ortiz, what does he do? Deny, 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 deny. Then he goes into blackouts. Then he goes into alcohol. Then selective memory loss. Dr. Shankar, I'm under all these pills. But yet, he remembered the most mundane things. Paying the gardener, going to buy pizza, what time his work schedule was back on September the 3rd. He remembered those things, right? What does that prove? Lies and inconsistencies. And you'll see the transcript. What were E.J. Salinas and Captain Calderon after? And we said it in jury selection. They were after the truth. That's what they were after. And what are we after in this courtroom today in Bexar County, San Antonio, Texas? We're after justice. And you are the ones that will deliver the justice. The voluntariness. He nods his head. His demeanor. What is the totality of what was going on? He consented to the search of his home. He consented to the search of his phone. He consented to DNA swabs. You have the video. He stood there and agreed to the GSR. He was cooperative. And that was Captain Calderon's goal. He told you. We were trying to get him to be cooperative. We were establishing rapport. There was no hidden tactics here, folks. This is a grown man, a law enforcement officer with a bachelor's in criminal justice, with a master's in business administration, 9-year veteran. He could have at any time explicitly said, "Guys, I know my rights. I want my attorney. I'm shutting it down." But he never does. He never does. You can listen to that and watch that CD 100 times. He never does. And look at the conduct of the officers. Let's get to the crimes. Melissa Ramirez. Melissa Ramirez, she knew Juan David Ortiz the longest. How do we know that? Through Erica's testimony, right? And even through the confession when Ortiz is talking about when he was with Melissa and they saw Erica one time. He was involved with Erica, both as a client and something else. The evidence has shown that. In his confession, he says that he took her to go buy her heroin, go get her drugs. Then he's driving around. He thinks about dropping her off at the hospital. But then he's afraid the cameras are going to pick him up. That's another interesting point. Look at where he always stops his vehicles. In every video, outside the view of cameras. Always concerned about where's the camera. Let me park behind the stripes. When he pulled the gun out on Erica, on the street behind the store. When he buys his beer at Murphy's, it's on the furthest lane. When he goes to the stripes on San Bernardo, it's to the furthest left by the dumpster. He knows what he's doing. He's calculating. So he comes here, he go during the confession, he says, she got off, she had to piss. She had called me a pendejo several times, and I said, that's it. Fuck it. I'm taking her out. And after she squats down, that's when I take her, while she's not looking. Pay attention. Pay attention to the evidence. And Dr. Stern, in this picture, I'm going to show you just this picture. Look at where the injury is. Look at where the injury is. The injury is on the inside of the wrist where he's left-handed, okay? The bullets went right to left. She gets up. Ortiz appears on her side, points a gun at her, and what would any of us do? She puts up her hand. The first bullet hits her right in the wrist, and it comes out. She saw the face of her killer when he pulled the trigger the first time, and he pulled it 3 times. That horrific last moment in Melissa Ramirez's life, she saw the face of her killer staring her down, a .40 caliber H&K, and shooting her 2 more times. The bullets were taken. The projectiles were taken that entered her face, near the ear and near the mandible. And what did Dr. Daniel tell you? They all came from the H&K. That fact, that evidence, Melissa is telling you in the last moment what she did. She wanted to live. She did not want to die. Claudine Luera, September the 13th. How many casings were picked up at that crime scene, if you all recall? It was 2. However, how many injuries did she have to her skull? It was 1. She was killed by a transgen. It was a big word, but the angle was the bullet split, the jacket separated from the projectile. She was hit 1 time. 1 time. But yet, there was 2 casings. When I first looked at these photos, I was trying to wonder and asking myself, Why are all her personal belongings strewn all over the grass? What was happening? What story is this telling us? What story is this telling us? That Claudine Luera, in her last moments of life, was trying to get away. She was trying to get away. She had her bag with all her goodies. She's struggling. All the contents of her bag are empty while she's fighting for her life. And then Dr. Stern comes here and says that the injury was caused more than 18 inches away. The first shot as she's running, boom! He misses. Gets closer, boom! Second one hits her in the head. She goes down and she's still crawling. She was still alive when she got to the hospital. When she was found by that truck driver, she was still alive. She died and succumbed to her injuries at the hospital. Claudine was a fighter. She fought for her family. She did not want to die. That is what the evidence tells you. Her tennies thrown there at the crime scene. And her last breaths at the hospital. He didn't try to scare her. He shot and he missed. I mean, this poor girl, what harm was she going to do? But he wasn't satisfied with that. He finished her off. Call it coincidence, or maybe not. But what did Ranger Salinas say? On September the 12th, I called the BIC and I requested information on a Claudine Luera. I was looking for Claudine Luera. On September the 12th, he testified to you that he made a call to a small intelligence center where this guy was at work, and he's asking, hey guys, I'm looking for this witness named Claudine Luera. Next day she's dead. Coincidence? There are no coincidences in this case. Pause it. So what does he do? What does Juan David Ortiz do? And I told you in opening statements that we were going to show you what he was doing in between and after murders. After Erica Peña escapes on September the 14th, he decides it's time. He's going to go clean the streets. But before he's going to go clean the streets, remember what time she escaped? It was about 9 o'clock. He goes, he buys his usual beer, the three Bud Light Tallies, and then he goes out to hunt. This video from 10:54 p.m. that Friday night, he buys those 3 beers that are in his truck before he hits the streets to go pick up his last 2 victims, Griselda Cantu and Janelle Ortiz. The evidence has shown that in less than 2 hours, from 10:54 up until the time he was caught, he killed those 2 women. Use your logic. Use your common sense. Do the math. Play the video. Mr. Bettis will want you to believe that on September the 14th of 2018, that this was a broken man. He was a man that could not function. He was a man in distress. He was a man whose life was falling apart, who could not make the mental or reach the mental state to do what he did. Look at his actions here. Are those the actions of somebody that looks like he's in distress? Or are those the actions that look like somebody who's just going about their business like anybody else does? Buying his 3 Tallies, getting in his truck, entering the pin, no problem remembering the pin, and walking out. He goes home, remember? He goes home. He tells Calderon, and he gets his house ready for an ambush. He takes out his weapons, puts them on the kitchen counter. His 9mm, his AR. He's getting ready because he knows that that bitch Erica was gonna go talk, and he's ready. They're gonna come and get me. I'm ready. But they don't go. It takes time. So what does he do? He gets back in his truck and he goes to look for more victims. Griselda Cantu. How many rounds were at Griselda Cantu? 3 rounds. You have them there. Another fighter. Why? Because he shoots her twice in the neck. 2 gunshot wounds. 3 casings. What does that show? His intent was to kill her. Then the blunt force trauma. She made the fateful decision of turning around and going back and talking to him about forgiveness. Again, you all know, I'm not going to spend a lot of time on this, but all of the consistencies and similarities, we hammered him home during the entire trial. You know him. You can go in there. You could write them down. I ask you, get in there and write down all the similarities and consistencies between the 4 victims in this case. Janelle Ortiz. 1 bullet to kill Janelle behind the head. And you saw in his interview, there's one more you don't know about. You want voluntariness? He volunteered that. Law enforcement didn't know. He volunteered where she was at and how he killed her, and the question he asked her right before, that she asked him right before, "You're going to kill me?" Yes, I am. Yes, I am. Fred Calderon, lead investigator, worked the murders and obtained the voluntary confession. You saw his questioning. He was professional. He did an excellent job in this case. Working together with Texas Ranger E.J. Salinas, who went back and found the additional casing, found the abandoned truck. They never, this is what's incredulous, that Pettis comes up here and calls it a preservation search. That term was never used. It's preservation photos. Preserving the area, the integrity, and that's what he was saying. He didn't search, he was taking pictures. He wanted in a more secure area to conduct a very important search for the evidence. His concern, when he saw the flashlight and the empty holster, you saw quickly, he backs up, gets on the phone. Guys, empty holster, careful, this guy's armed, he has his gun. That's where E.J. Salinas' focus was, on his brothers, who he didn't want to get ambushed. That's where his focus was. Dr. Corrine Stern, all the injuries were from the neck and up. All of them had issues with substance abuse. All of the injuries were executions from the neck up. Sean Daniel, remember, he connected all of the murders to this .40 caliber H and K. All of the 9 casings, the 6 projectiles, all came from this gun, this government issued weapon that he had in the side door panel of his truck, with the government issued ammunition. Yes, sir. Science does not lie. 12 bullet capacity in the magazine, and Ortiz H and K, 1 in the chamber, 13 total. When this weapon was found, there was 9 in here. Do the math. You add the 3 from Griselda's crime scene, and the 1 topped off, it's 13. like any law enforcement officer, look at the evidence. His magazines were fully topped off. 37 rounds he had in his truck before he went out on the road looking for more victims. 37 rounds. Lonsberry, the tire. It's the first time I ever see a tire cast match the tire. It's right here. Look at the imprint. A perfect match to Ortiz's truck. Sarquis, what was Ortiz's only concern on that phone call? My confession. They don't have any evidence, babe. All they have is my confession. Well, he's wrong. Bettis is wrong, and Fuchs is wrong. You have a mountain of evidence. That's the whole story. And I'll finish with this. And I told you in opening statements that there's moments in your life that are marked when things happen. And this is one of those moments. That's when time is divided into two areas. Before the event and after the event. You've lived through this event now. And only those strong people can move forward and find the truth. No matter what. And the truth here is that Juan David Ortiz committed capital murder of Melissa Ramirez, Claudine Lueda, Grisela Cantu, and Janelle Ortiz in a common criminal episode. He is guilty. He is guilty. And when you go to that verdict form, you have it. You turn to that last page. Right here. On page 19. We, the jury, find the defendant, Juan David Ortiz, guilty of the offense of capital murder as charged in the indictment and as instructed in this charge. He is guilty.
Ladies and gentlemen of the jury, you've heard the closing arguments. I have the charge of the court. I'm going to hand to our bailiff, and he'll place it in the jury deliberation room. And once all 12 of you are there, you may begin your deliberations. I'm going to ask our two alternates, Graciela Delgadillo and Rhonda Swift, to please remain in the courtroom for now. And I believe there should be food served already, correct? All right. All rise.
All right, the jury.
We have food for the alternates. Yes, they can. Ms. Graciela Delgadillo and Rhonda Swift, you were our two remaining alternates. We want to thank you for your service. Again, as you know, we had two alternates that had to come in and take the place of 12 of the original jurors because of things that came up. So we thank you for your service. I'm going to excuse you at this time. Thank you. The court will stand in recess at this time. Ooh, the lights over here look like they're off. I don't know. It just looks. Thank you. Right, jury's reached the verdict. Can we bring the jury in, please?
Yes, sir.
You may be seated. Has the jury reached a verdict? Was it a unanimous verdict?
Yes, it was.
Can you please hand the verdict form to the bailiff? Can the defendant please stand? In front. Verdict form. We, the jury, find the defendant, Juan David Ortiz, guilty of the offense of capital murder as charged in the indictment and as instructed in this charge. Signed by the presiding juror. This is your verdict, correct? Thank you. Mr. Ortiz, you heard the jury's verdict. You have the right to allocution, which means you have the right to make a statement if you wish. Okay, so they're asking for the jury to be polled, so meet the juror list. Well, I'm just going to call you by number from the back. Juror number 1, can you please stand and tell me, was this your verdict? Well, okay, in the front.
Guilty.
Juror number 2.
Guilty.
Juror number 3.
Guilty.
Juror number 4.
Guilty.
Juror number 5. Juror number 6. Juror number 7. Juror number 8. Juror number 9. Juror number 10. Juror number 11. And juror number 12.
Guilty.
Thank you. You may be seated. So, Mr. Ortiz, as I was saying, you have the right to make a statement if you wish. Would you like to make a statement at this time? No? Anything else?
Nothing for the defense.
All right. And Mr. Alanis, were there going to be victim impact statements made?
Yes, Your Honor, after the court
Okay.
opposes sentence.
I just wanted to make sure that,
Yes, we
Yes.
have representatives of the family that would like to make victim impact statements after Mr. Ortiz's sentence.
correct. So, Mr. Ortiz, at this, as you know, I'm sure your attorneys have informed you and you've heard throughout the trial, this charge of capital murder has an automatic sentence of life in prison without the possibility for parole. So at this time, the court is going to assess the punishment of life in prison without the possibility of parole. That is your sentence at this time. Mr. Alanis?
Your Honor, at this time, I'd like to ask any family member from representing Melissa to please step forward. Melissa Ramirez. Hold on. Handcuff. Before you start, 1 second. Yes, I'll arrest her.
And you do have the right to appeal this verdict. I'm sure your attorneys have informed you of that as well. Are you at this time asking? Yes.
Yes, Your Honor.
Okay. You want to have an attorney appointed for that purpose?
Yes. We'll file the preliminary.
Yes, sir. File the paperwork so I can, I know that at least one of you is not going to be available, so we'll see who the appellate lawyers are that are available on the list. All right, anything else? No, not those impact statements. No.
Melissa Ramirez's sister-in-law. Melissa was a loving, kind, and funny person. She always looked out for her kids. Melissa was not alone, so I'm here to speak up for her. I can't believe you took her life with no remorse. Melissa was more like a sister to me. She was the best person I could ever be with. I loved her so much, and I still do. I was always there for her, but sometimes I couldn't be there all the time. You took someone's daughter, sister, mother, and friend's life. How could you? She left her kids behind, and now their hearts are broken, knowing they won't be able to see their mom again because of what you did. Do you know how much pain you have caused to this family? Do you know how many times I wish for Melissa to show up to my home and see her and hug her and hear her voice again? I hate you for what you did, and I can never forgive you, nor do I think God will. You deserve to suffer in prison and go to hell. I still mourn for my sister-in-law. Even though it's been 4 years, I feel as if it happened yesterday. My heart is torn apart knowing that I won't be able to see her, but to visit her in the cemetery. Monsters like you don't even deserve to breathe, nor wake up to every morning. You are a turd, so take back those words you've said to these beautiful women. You deserve to die and suffer for what you did, and when that day happens, I will finally be in peace.
Yo soy la mamá de Melissa y quiero empezar a preguntarte a ti, monstruo, ¿por qué la mataste? ¿Por qué mataste a mi hija? Si ella tenía hijos, tenía hermanos y tenía una madre. Mi hija no estaba sola y dejaste a sus hijos huérfanos. ¿Por qué te ensañaste así con ella si estaba indefensa? Melissa no tenía maldad. Ella era noble, sensible. ¿Qué daño te hizo para que te ensañaras así con ella? ¿Por qué le quitaste la vida? No tenías derecho. Tú no eres nadie para decidir por la vida de otra persona. ¿Qué pensabas cuando jalaste el gatillo a quemarropa por más de 3 veces contra alguien indefenso? ¿Qué sentiste cuando callabas con 3 balas sus gritos de súplica? Yo sé que Melissa no significaba nada para ti, pero para mí era mi vida. Y ahora mi vida está destrozada por su ausencia. Eres un monstruo que no merece estar respirando el mismo aire que yo. Ojalá que tu vida sea un infierno cuando estés en prisión. Cuando supe que la encontraron sin vida, sentí que me iba a morir de tanto dolor. Fue tan grande mi pena que mi alma no pudo habitar más dentro de mi cuerpo y me desplomé entre sollozos y gritos. Ya pasaron más de 4 años y de mis ojos aún salen millones de lágrimas. Melissa era mi hija, mi más grande amor, y ahora por causa tuya ya no la puedo tener conmigo. Tú no te imaginas el daño que causaste a sus hijos. Maldito asesino. No sabes cuánto te aborrezco, eres un monstruo. Tus hijos siempre serán los hijos de un asesino. Y cargará con ese estigma el resto de sus vidas y les llamarán siempre el hijo del asesino. Eres un maldito monstruo asesino y deseo que cuando te toque morir, que tu muerte sea dolorosa y larga, que te vayas al infierno ahí donde ahora perteneces. Y ojalá que tengas el valor para quitarte la vida así como se la quitaste a mi hija.
Fucking coward.
Valdingo era.
Years have certainly flown by rather quickly, but have felt like an eternity for our families. Our lives came crashing down as everything started to unfold on September 14, 2018. You stated you were cleaning up the streets of Laredo, but as we stand here today, Mr. Ortiz, Mr. Alanis and his team did just that by removing individuals like yourself from our streets. When becoming a federal officer, Mr. Ortiz,
You swore to protect and to serve our country, but sadly you failed to do so. Mr. Isidro Alanis fulfilled that duty today. The extent of your actions have caused so much pain to so many people, including your own family. Just as we have lost our sister, my nieces and nephews have lost their mother, and my father lost his daughter. Your mother lost her son, your wife lost her husband, and your precious children have lost their father. Your family has mourned their loss along with ours. They will continue to be in my prayers. I will pray for their strength, and I will pray for peace in their hearts. I've carried so much these last few years, Mr. Ortiz. The pain and anger have been the hardest to bear. Today, I am wholeheartedly letting go and letting God handle what my heart cannot. Forgiving is part of healing. Today, Mr. Ortiz, I am choosing to forgive you, because I know in my heart that Melissa, Claudine, Giselda, and Janelle are resting peacefully in the heavens above. I will now read a brief statement from my nephew, Claudine's son. What you did to my mother, Claudine, was a horrible thing. I forgive you, but only because forgiveness is not for you, it's for me. She would not have wanted me to feel that burden of what you did on me. You ruined so many dreams that my siblings and I have, but instead of despairing, we will create new dreams and paths because my mother would have wanted us to. You will be long forgotten in our memories and locked up until you die. But my siblings and I will move forward in the future, knowing that our mother, Claudine, will always be by our side.
I am the youngest daughter of Claudine Luego. You took my mom away from me. You ruined any chance I could have to having her in my life. The pain of having to lose my mom when I was only 17 years old. I was still a kid in my junior year of high school, September 13, 2018, when I experienced the worst day of my life. I was picked up from my high school and I was driven to my mother's sister's house, and all my family gathered together to break the news to me and my brother. We were told that my mother was killed. My heart broke into pieces at that very moment, and being told that you killed my mom, that was heartbreaking. I was at a loss of words. I was in shock, but all I could do was cry and be angry because I knew I was never going to see my mom again. I was never going to hear her laugh. I was never going to be called mamas or her little girl from her again. I was never going to be able to hug her nor be able to hear her voice anymore. I started grieving at my new reality that my mom was taken away from me so suddenly from my life. You, Juan David Ortiz, you didn't kill just women. You killed women who mattered, women who were loved by so many people. Those women were loved beyond measure. You will always be known and remembered in our community and in Laredo, and to the whole world, you will be known as a monster. You said you wanted to clean up the streets of Laredo. Our streets in Laredo will only be clean when people like you are put away in jail forever. You hurt my family, you hurt the other women's families, and you broke your own family. My mom had 5 beautiful children. You didn't just take her away from me. You also took her away from my brothers and my sister. I have so much pain in my heart, but having to witness how you killing my mom affected my brothers and sisters broke me. Having to hear them cry because of losing our mom was one of the most heartbreaking experiences in my life, and I couldn't do anything to console them. I was just a kid. My siblings and I, we were just kids. I got so depressed, I got put in a dark hole because of my mom's death. My mother was a part of me you destroyed, and I wanted to destroy the rest of me out of despair. You failed in destroying these women because their memories, their legacy, they themselves will live on.
and their children and the people they impacted in their lives. They will always be remembered and never forgotten. They will continue to live forever in our hearts, while you will only be left to be forgotten and no longer a part of society. The one word to describe your life from now is exile. The word to describe the life of these women is they will be cherished and will always be part of our lives and the people touched by them.
My name is Joey Cantu. Chelly Giselda Cantu was many things. And yes, she was a drug addict. She was a prostitute and she was a felon. But she wasn't always these things. And maybe one day she would have ceased in being these things, as her family had always hoped. But you have forever robbed us of that hope, that one day she would come back to us. It is said that hope springs eternal, and it's true, until someone like you comes along and completely and utterly destroys that hope. You'll hear no cliches from me about my sister, that she was this or she was that. My sister was a good person, yes, but she did bad things. Bad things not motivated by malice, not motivated by hate, but by addiction, by her disease. She was sick, as were the rest of these girls. I'll tell you what my sister was, and what always will be. She would always be the 6-year-old little girl She was all I had, bro. She was all I had left. You took the last living member of my family, man. She would always be the 6-year-old little girl who would wake up in the middle of the night to walk her 8-year-old brother to the restroom because I was scared of the dark. She would always be the little sister who defended me from bullies when we were in elementary school, even fist fighting them. And she'll always be the little sister who cried just because she saw me crying. My sister was empathetic and she was compassionate, as evidenced by your conversation with her. Her knowing what was likely going to happen to her and still choosing to talk you out of suicide. Showing you compassion, sympathy. She did not beg for her life. She begged for your life. She'd tell you it didn't matter what you had done, that God would forgive you, that God would always love you. And that was my sister in a nutshell. And in the face of that empathy and compassion that was surely God-given, you responded by violently taking her life. I guess it's true that no good deed goes unpunished. I've now had to live a life in which I've endured and suffered the murder of my mother, the murder of my father, and now the murder of my sister. It would be so easy to hate you. Too easy. But I've always abhorred the path of least resistance, and I don't hate you. I don't hate you at all. And I won't hate you, but I do hate what you did. Not only to her, but to all of us. And here's the irony. Roughly 26 and a half years ago, I stood where you now stand, accused and convicted of murder, sentenced to 40 years in the Texas Department of Criminal Justice. I spent 22 years and 11 months of my life in prison, from the age of 15 to the age of 38. When I was granted parole, the sister of my victim wrote me and told me that she forgave me for what I had done, and that I should forgive myself as well. And now I find myself here in front of the person who killed my little sister, and I want you to know that I forgive you, and I hold no ill will towards you, man. I pray that one day you find the peace that you have ripped away from all of us. You spoke of God's ability for miracles. Well, your miracle is that you get to continue living, to continue to see and hear from your loved ones while we no longer can. When in any other circumstance you would be facing a death sentence, and know that it was me, the brother of Giselda, who asked the DA to consider going without the death penalty. Because your family has suffered as well. No parent should ever have to watch their child die, even yours. I leave you with the words of my sister. No matter what you've done, it doesn't matter. God will forgive you and God loves you. May you find peace and freedom in Him. But I'll forever wonder if maybe Erica was not who she was, if Erica was not a prostitute and a drug addict, if swifter action could have been taken, would they have believed her and should have been an upstanding citizen? Would it have taken 4 hours to find him? 3 hours, 2 hours, however long it took? You're not entirely your fault. We were failed at times by the justice system too.
I'm Monica. I'm a beloved relative of Kelly Cantu. I have heard comments that you mentioned you wanted to clean up the streets. Who are you to consider yourself so worthy to clean up the streets? If the girls were so unworthy to be in the streets, you were right there with them. You knew that they knew you by your first name. You were given 2 weeks to present your side of your innocence. You were given a different venue to avoid bias against you. You were given a jury of your peers, thousands of dollars to decide your verdict. You did not give the victims any opportunity that you were given to decide their verdict. I heard you were deprived of a meal. Oh, you're still malnourished. What were the girls deprived of? They were deprived of their life. I heard that this country, there is laws, and every I had to be dotted for the case, and every T had to be crossed. But this country of laws, they were not followed for the girls. The streets of Laredo are being cleaned and getting rid of you. You are the filth of the streets of Laredo. I have something in common with you, though. I too believe in death. Death sentence. I too feel justice needs to be served by death, and that is by killing you. No more tax dollars should be spent on you, on your meals, your housing, your medical bills when you get sick in jail. The only good of you now really is to donate your organs, if anybody would even want them.
My name is Isabel. I'm Shirley's older cousin. She was my little cousin. I stand here in front of you to let you know that Shirley and these girls were they were not alone. You said that Shirley and these girls were nothing. You said they were trash. You said many harsh words. First, these girls did not do drugs because they were evil. They did not do drugs because they wanted to get high and have a good time. I'm a psychiatric registered nurse. I study these type of human behaviors. These girls did drugs they were self-medicating. They were using street drugs to cope with life problems. They were lacking the proper coping skills. They needed help. What you did was not helping them. It was not cleaning the streets of Laredo. I hope that one day you can see. I hope one day you can see that you did wrong. And I hope one day you can see how many families you hurt.
I'm Brianna. He's a youngest child. I was 14 years old when he took my mom away. I was immature. I couldn't understand and comprehend the situation. And real honesty, I wanted you to feel my pain. Real pain. You robbed me from meeting my mother.
and getting to know her as a person. Yes, my mom was she was a drug addict, a prostitute. She maybe didn't mean nothing to y'all. She meant everything to me. And you robbed her from me getting to know her as a person, because she wasn't just that. She really wasn't. And that's okay. She lived the way she lived. That's her problem. That's her lifestyle. Yes, we get it. But fast forward, I'm 18 now. I haven't gotten closure, and I'm not sure I ever will. I've struggled with a lot coming to this age. Anger mostly. I wish I could make you feel pain, to be honest. And I hope one day you do get the pain you deserve. It's like it made me go numb to this point. I don't feel sadness. I'm mad. I'm real mad. But I can't be angry no more. I can't. So I forgive you. Like my mom said, God forgives you and He loves you. And I know deep down you hate yourself for murdering her. You even said it in your confession and everything. Trust me when I say what she said is going to be on your mental for the rest of your life. She was a compassionate person. She loved people. She really did. She loved her brother. She loved her tia. She loved everybody. She loved everybody. And even after you killed her, what she said, she wanted to help you. She wanted to help you. You were suicidal? Who was there? My mom. My mom tried to help you. That's not okay. That's not okay, bro. And she was everything to me. For a fact, I know she loved her children, but her lifestyle and demons took over. And speaking for my siblings, and you, Juan, cheated us out of ever getting to hear her side of the story, on why she gave us up, and understanding on what made her into the person she was. I know I said I forgive you, but deep down it's not for you. It's really not. It's for me to find peace of mind. Karma is a big thing, and your karma is just slowly starting from here. Trust me, you're not going to make it in there. I hope you don't. And you will suffer. In my heart, I know. I hope and I know you will not make it in there. And surely you know your day is coming up. And then, God bless you and your family, because you tore your family apart just like you tore ours. And you will suffer. Promise you, you won't make it in there.
As the Humberto, hermano, please. Okay, Jenna Ortiz, youngest sister. As the youngest sibling, I never thought I'd be going through this experience right now. It's a lot of emotions. You probably don't know, because you don't know it's like losing a sibling. On September 15 of 2018, a piece of me left unexpected. Everything went blank. Nothing sad enough. But she knew how to fight back. She wasn't afraid. I had to go look for her because I couldn't have been transgender, we all thought. We have to find out it was you, Juan David Ortiz. You left me with no words. You had everything in life as a border patrol agent.
How could you? Why didn't you put up a fight against Janelle? I guess not so tough, right? You got to end her life. What triggered you to go through it? Like if there were dogs, taking them on a cruise and then thinking it was? Because you weren't doing anyone a favor by cleaning up the streets. It was not your duty. My sister and her friends weren't trash for you to go do what you did. You don't know the love they still had at home. No matter what lifestyle they chose to live or battles they had, they were loving. They still had kids to go home to. I still can't find the words to say, but this has impacted our lives and the community too. Foremost, I'm not the same person I was. I had a smile before getting that traumatic call that changed my whole life. I used to be full of life. I was looking forward to meet with Janelle to register for college. She always loved occupying me everywhere. Sadly, I don't get to hear that no more, nor her reminders to keep my head up high and that I'll always be safe while she's alive. As I'm here talking, expressing my feelings of how you affected not just me but other families, I just can't seem to stay mad forever about it. I'm mad at the fact that you gave your word to protect the border and serve the people, yet you felt you betrayed your badge in the system. We're all grieving. I just don't know how I will forgive someone who showed no remorse. I never put myself in this situation growing up. But in order to move on with my life, God says otherwise. I can't question him because he has his reasons. But I know Janelle would have fought hard. I don't have hate towards you. I just hate the fact that you didn't have a heart while doing it. As we suffer these past years, you deserve to suffer the consequences. I don't desire nothing bad towards you, but me. Justice fits her. Because what you caused was nothing pretty. My sister is gone and so are her friends. You are still breathing, but I have faith and I believe you will get what you deserve. I pray your family doesn't go what we went through. They're not to blame, but you took 4 lives in the most cowardly way.
That's all the state has to.
Anything else from the defense of the state?
No, not from the
Okay, I'm going to remand the defendant to the custody of the Sheriff's Department at this time. Court's adjourned. I need someone to take